जब बनने लगेंगे तो उसकी वोटिंग के लिए हम लोगों ने सीनियर एडवोकेट्स चूज कर दिया था, सीनियर एडवोकेट विदाउट एनी रेम्यूनरेशन करके। Yes.
What? Any mention in daily board serial number 1 to 6? Any other mentioning?
There is one matter which is coming up on Monday at item 12. The record is very bulky. I am not in town, so that your lordship may not have to read. Requesting for some other
We
date.
cannot adjourn the
No,
matter
no, mentioning would be
today
made.
for Monday.
No, no, mentioning would be made on Monday. Your lordships may not trouble your lordship with reading because record is very bulky.
Okay.
Therefore, I am mentioning in advance. Not that I am requesting for adjournment today.
He doesn't know that that won't be. Okay, fine.
Please, your lordship. My friend would mention, no, she is on.
Daily board serial number 1, Mr. Nachiket.
This is pertaining to a PIS because of the village site, the entire village is before Lord's Milords. What has happened is they have not encroached government lands, they were ponds which were dug up Milords and dug up not for 5 10 feet, dug up for 70 feet Milords. The sand was stolen. Because the sand was stolen, it was Milords, it was illegally mined because the government roads, lakes, ponds have been encroached. They have been made into larger roads, and those have been sold to private industrial units, Milords, for the purpose of helping them, Milords. And Milords, not only one of the plots.
Who has sold them? Who has sold them to private units?
I would.
Can you give us
Yes, no, it is
your
sold.
grievances one by one? You are in a lot of hurry. We are not in hurry.
So it is sold by Milords, respondent number 4 and 5 Milords. Milords, may see respondent number 4 is the present Sarpanch, and respondent number 5 is the ex-Sarpanch. So during that terms, we started.
You have not impleted Gram Panchayat?
No, Milords, they don't need it because Milords, 5 Milords, because it is Milords only at the behest of the Sarpanch. What has happened?
Mr. Counsel, if we are required to seek the comment of the Gram Panchayat, how would we get it? In any case, it is the land of the Gram Panchayat?
Is government.
Yes.
Yes.
According to you, the Sarpanch of the Gram Panchayat is illegally selling up the
Yes, Milords.
or allotting lease, right? Gram Panchayat is not party. The owner of the person, the legal person who is otherwise authorized to manage the land, that is not party. Do you understand what we are saying?
Yes, sir.
Then, is it necessary party or not?
I impeded.
So then why are you arguing on this issue?
I impeded.
I don't understand that. Why do you don't understand what the court is asking you?
So Milords, I impeded them.
And then the description of respondent number 4 and 5 is also to be corrected because you want to implead them by name, right? So if you implead them by name, the name has to come first and then their designation, and then parentage is not there. How would you identify a person? Without parentage, can you identify a person? There may be 2 persons of the same name. Then
I put them, son of daughter so and so, son of so and so.
Manubhai, Kikabhai, Gamit, maybe 2 persons. We don't know.
I'll tell you.
Whenever you implead a person by a private person, his entire parentage has to be there along with the residence. Make these corrections within the course of the day. And counsel for the petitioner. Praise for and is granted permission to implead Gram Panchayat concern in the array of parties as respondent number 6 and make correction in the description of respondent number 4 and 5 within the course of the day. Yes, proceed.
Yes, Milords. So Milords, this is the case. Milords.
What is this? Who is this? This respondent number 3?
Milords,
What do you mean by this? Geologist. What does this mean?
Milords, kindly see, Milords, there's a
So then this department is also not properly implemented. The department has to be implemented by the head of the department, through the head of the department. It cannot be implemented by any one officer of the department.
I'll make.
Every state department has to be implemented through a head of the department or not?
Yes. So I'll make all these corrections in terms of, naming them properly, saying that head, this is, I'll do the, may kindly say-
And then,
Hmm.
then you have implemented state of UP through the Commissioner of Geology and Mining Department. Is it proper implement? No. The state can be implemented only through a secretary. Secretary who is in charge of this geology and mining department. So it's better that you make corrections in all the matters,
all the costs.
for all of them. So do it. Not today then. Not today.
Next week.
लिखिएगा, learn and within the course of the day हटा दीजिए. He is also required to make correction the description of respondent number 1 and serve the notice for respondents 1 and 2 in the office. Serve advance notice on behalf of respondents 1 and 2 in the office of the learned government pleader. First stop. To complete the said process, comma, as prayed, put up this matter. Next Friday लगाइए.
Get to that. No. 8 of. Yes.
This is the first lesson you must learn, and you should not repeat this again.
Yes.
State is never implemented by any department only. It is always represented by the concerned secretary.
Serial number 2, Mr. Maulik M. Soni, learned public.
Hmm.
Matter pertains to land grant, but on the last location when the matter was placed,
Have you filed affidavit? We have granted you time.
detailed affidavit is filed. Detailed affidavit is filed and is found record.
Additional affidavit. What do you see in the additional affidavit?
Lordship, that
We were asking you to indicate the right which you have in the land in question.
please, Lordship, the father of the respondent number 4 have made an mortgage deed in the year 1967 in the favor of grandfather of the present petitioner, Lordship.
Where is the mortgage deed?
Lordship, which is Annexer C, page 33.
33. This mortgage must have been redeemed. Why was this mortgage? There was some personal loan? Why was this mortgage? What is the reason of execution of this mortgage deed? Can you read from the deed? Page 33.
I'll supply translated.
It seems that 3,400 rupees
In the year of
were taken as loan in the year
1967
1967.
and since
And that is how this mortgage deed was created. Have you ever stated in any of the paragraphs of the affidavit that this mortgage has not been redeemed?
400 is rupiah.
Acha, okay. Only 400 rupees. 3,000 is not. That is rupees.
Rupees.
I always get confused.
in the revenue record also.
So for 400 rupees, this land was taken, given on mortgage in the year 1967. You have not stated that this mortgage has not been redeemed. So he has no option but to file a complaint against you. You are illegally occupying the land.
In 1967, this mortgage deed is not challenged by the private respondent.
No, there is no need for it to challenge the mortgage deed, Mr. Counsel. The mortgage is redeemed with the passage of time. Unless and until you make out a case that this mortgage is never redeemed, and even otherwise, the mortgagee is entitled for redemption of the mortgage. You cannot keep the possession in rupees 400. That was a loan given in the year 1962, 67.
67.
Okay, in the additional affidavit filed on behalf of
In this case, I may request for the next week.
Sorry, filed by the petitioner,
I may take
Comma.
instruction.
no, comma, it is submitted that in the year 1967, comma, the father of the complainant,
Yes, Lordship, I may request for
namely
withdrawal.
respond number 4,
Withdrawal.
no. It's not a case which we permit you to withdraw. Father, exploitation is
It may
already
only request- it may be kept at
for
2:30,
years
Lordship.
together, he has been exploited. No, at least he's getting an opportunity to get his land back.
Lordship, only request, it may be kept at 2:30. I may take instruction, Lordship, by today itself.
Today is Friday.
We have already granted you time. Okay, Liva? 1967, comma, the father of respondent number 4, namely the complainant, had executed a mortgage deed in dated करेगा 8/5/1967 in favor of the grandfather of the petitioner, namely Ram Singh Bhim Singh. Full stop. Since the grandfather of the petitioner was accordingly in possession of the subject land since thereafter. Full stop. It is further stated that after death of the grandfather, comma, the father of the petitioner was in possession of the land in question, and the petitioner has occupied the same after death of his father. Full stop. It is further stated that the name of the grandfather of the petitioner, namely Ram Singh Bhim Singh, had also been recorded in the revenue records. Where is the name of your grandfather? Can you show us?
Lordship, at Annexure B,
Page 31.
31, Lordship.
Name. Where is the name of Ram Singh Bhim Singh?
Lordship, at the bottom of the left hand side,
Hmm.
Erutna Nam, Ram Singh Bhim Singh.
No, it is not Ram Singh Bhim Singh.
Where are you reading?
This bottom.
Yeah,
This is not Ram Singh Bhim Singh.
Rama something.
It is not Ram Singh Bhim Singh.
It is Rama something, not Ram
It's
Singh.
not Ram Singh Bhim Singh. Rama Bhima.
Acha.
The same
Full
person,
stop.
Lordship.
And what is the date of death of your grandfather? These entries are up till January 2004.
2005.
Please, Lordship. After
Five.
2005, it
Nothing is
was
there.
online, Lordship.
There is no description, the revenue entries. And where is the number? This is survey number
16.
1216. This year 2814.
2814, Lordship.
Huh?
Survey number
And this entry is survey number 1216. It is not 2814.
So page form number 12 would only indicate the possession or the possessor of the land.
No
So
right.
yes,
No, otherwise also come to page 31.
yes. Please.
The survey number is 1216. It is not 2814.
But it may have so been
Change.
that thereafter promulgation may have happened and it may have been.
He doesn't say so.
Yes, he does not, of course.
It is
It was the old.
the copy of the
You have not.
revenue entries of survey number 1216 has been appended as an Annexure B to the writ petition to assert that the name of Rama Bhima has been recorded in the revenue records. Full stop. However, suffice it to note that the name of father of the suffice it to note that the dispute in the present matter pertains to survey number 2814, Khata number 478, village so and so, paragraph 3. It is not possible for us to relate the revenue entry at page 31, which pertains to survey number 1216. First off, moreover, the village form number 7 hai. This is village.
Village form number 12.
7/12.
7/12.
Because this particularly is village form number 12, where he says that his father's name is.
It is 7/12 or 12?
7/12.
So plus the upper part is village form number 7. The
Acha,
lower part
okay, lower
village
is
form number
7.
12.
Okay.
Hmm.
The, okay.
So if your lordship were to see here, in
So
this
whether-
column, his name is not
Yeah,
featuring. So he's not
okay.
featuring in village form number 7.
7/12 is the
The
record
entire
of
form.
right.
No,
So it is the entire village form. Village form
It
number
shows the
7
holding.
is record of
only the
right.
holding part.
Village form number 12.
This is
the
what we are
description of
trying to
possession.
understand.
6 is the right, form of rights.
Plus that will be the description of the entry. So plus
Right,
if your lordship were to
right.
consider this entry 963,
Hmm.
its description will be in village form number 6.
6,
Yes.
right.
So the upper part is village form number 7.
7.
The lower part is village
12.
form number
So what
12.
does village form number 7?
Was a village form number 7 will have all the record of rights. So every mutation entry with respect to a record of right will be reflected in village form number 7.
His name is not there in.
No, it's not there.
लिखिएगा.
His name only features in village form number
Oh,
12.
per usual of Annexure B at page 31 of the writ petition indicates that at 31 of the affidavit, additional affidavit, 31 of the paper book indicates that in village form number 7, comma, there is no description of name of the grandfather or father of the petition. Full stop. The entry with respect to the name of grandfather of the petitioner, allegedly as Rama Bhima, in form number 12, only pertains to the possession, pertains to the right of possession.
Because he tills the land. He's a tiller. But if you lordship to see, Pedut Nuna, so he can be a tenant also. He is stealing the land. That is
So
why
he is
it's-
in possession.
Yes.
He is in
The
possession.
only pertains to the possession entries and does not confer any right or title in the land in question. Full stop. Para change करें. It is, moreover, it is not indicated either in the writ petition or the affidavit or the additional affidavit that the mortgage of rupees 400, comma, which was for which mortgage deed dated 8/5/1967 was executed had not been redeemed. First step, para change करें. For all the aforesaid reasons, comma, we do not find para change करके लिया. Moreover, it is correct. It is further relevant to note same para. It is further relevant to note that even the name of the father of the petitioner or the petitioner himself has never been recorded in form number 12. Full stop. For the aforesaid, comma, we do not find any good ground in the contention of the petitioner that he has a right to retain possession of the land in question based on the mortgage deed dated 8/5/1967. Full stop. For all the aforesaid reasons, comma, we do not find any merit in the writ petition. The same is accordingly dismissed. This is an inquiry notice,
It is an-
final notice.
No, preliminary inquiry notice by deputy collector to the Mamlatdar to inquire into the matter. Not even to him.
We do not find any, do not find any merit. इसके पहले देखो जी. This apart, comma, it is relevant to note that the notice dated 7/9/2023, which is subject matter of challenge herein, is a communication by the deputy collector to the Mamlatdar to make an inquiry into the matter. Full stop. At the stage of preliminary inquiry, comma, for the facts stated, noted here and above, comma, we do not find it a fit case to interfere. The writ petition is accordingly dismissed. इसकी जमीन सालों साल चली गई. Yes.
Serial number 3, learned government leader.
State government.
The costs that your lordships have imposed are but
Yes.
the costs that your lordships have imposed upon us are perhaps not deposited. Because I will need only a day or two more so that I can pursue it. Because your lordships have, while rejecting our appeal, because I had imposed a cost of rupees 15,000 on us.
Have you filed any recall?
I'm sorry, no, but we have to deposit those costs. That is, since up till now the deposit is not made, that is how it comes for orders before your lordship.
So what do you want?
But I need some more time so that I can
How
pursue it.
much?
By next week, we'll see to it that it is deposited.
And this litigation policy, have you
That I'll
gone
have,
through it?
yeah, because I'll have to pursue with the legal department on that regard also.
The litigation policy is there,
Is already there, Mills. Is already there.
but that litigation policy has to be looked into. Have you seen the litigation policy?
No, Mills, not. That is how I will go through it, and then because I can revert back to your lordship's question.
Hmm. Because once if they take decision or opinion of the advocate, then that would be end of the matter. Do you have the copy of the litigation policy?
No, not at present. I can get it, Mills, if you ask it.
This is the main committee.
The government leader of the High Court. Committee may invite secretaries of government expert on the new cases to attend the meeting. So they will decide. कुछ रहने दें.
District level पे भी बन दिया.
Whether any committees, this committee would also look into the appeal and everything.
Yeah.
Yeah. Okay. You incorporate in this litigation policy about advance notice also. For all state authorities, including the secretaries.
Very.
See, that advance notice will be received by the office of
The government. Lordship.
GP. And I also will go through it. I have not gone through it extensively. PP also. In all such matters like writ petitions. Appeals may on all such matters, writ petitions. The original jurisdiction. कोशिश में तो होनी चाहिए. Revision will be in some method. Revision. People original jurisdiction. We will go through this policy. We are keeping it after 1 week. Next week. Next Friday.
Grateful.
By that time, we go through it. We will discuss also.
Next is more.
Serial number 4, Mr. Varun Patel and Ms. Shikha Banchal as the amicus curiae, K.R. Kosti. Mr. Utkarsh Dave by Seshnu.
What was the last order?
technically from the same.
So in fact, the state was required to report the action
The
taken.
affidavit is ready, which we are filing it today.
Colleagues.
The recommendation.
Hmm. Hmm. Yes,
You know,
by order dated 10/10/2023, comma, on receipt of the report of SIT, looking to correct, considering the final report dated 9/10/2023 of the SIT, comma, filed in the court, comma. Filed in the court. The court has filed in SIT, comma, on the request made by the learned Advocate General. The matter is posted today to place the action taken report of the state government. First of, on the today, on the request made on behalf of the learned Advocate General, the matter is posted on next Friday. Next Friday? Is it possible?
fine.
Regarding government neighboring land was in the matter of state.
Serial number 5, Mr. Prerak Oja, learned public person.
Even later, that it was heard on last occasion and my lord have permitted me to file an additional affidavit wherein I was to state that I am in possession of the land which is as per my sale deed within the core boundary of my sale deed. That affidavit has been filed by me. So page number 35 is my additional affidavit.
You have filed a reply to the notice.
Please, I have it.
What do you say?
Paragraph number 4. That in pursuant to the allegation leveled by respondent number 1 complainant against the petitioner regarding illegally occupying the land and grabbing the land of the respondent number 3 complainant, it is submitted that the petitioner is not holding the land in as much as within as core boundary of the sale deed dated 9/12/2019 registered with the sub.
When you submit a reply, they will make an inspection.
Lordship, I have already submitted my reply.
They will
But
make an
Here,
inspection.
my only say is here, if I may permit,
Spot measurement would be carried out.
we have already made an application for DILR also on our part for clarification that we are only holding the part within the core
No,
boundaries
no,
of the
the authority which is working out this land grabbing matter, they are the state authorities. The collector can always constitute a team
Oui.
to make a spot measurement
Oui.
to see as to whether you have acquired the land beyond the or there is any
You
encroachment.
can make an application for measurement to
I have already
the
made.
DLIR office.
It's done, but that would
But
take
here,
further
the
time.
only issue
So it's
is
better that collector
regarding
will look into.
overlapping of
These
the land.
authorities can always look into.
The only issue for my lord is regarding overlapping of the land,
Hmm.
wherein the complainant is the adjacent plot holder. So he is holding the plot on the east side of my land.
See, let the team constituted by the collector carry out the spot measurement.
Yes.
If there is some issue in relation to correction of village map or some entries or some overlapping of land,
Yes.
which would require an order by the revenue authorities, they will take appropriate proceedings.
Even in my reply before the inquiry authority, that is the PI Harvard, I have made a specific government before the authority also that I am ready and willing to go by any of the mode of for settling the dispute between the parties for any mode suggested by
Okay.
them.
So we are
That reply-
disposing of with the observation that The competent authority, they will carry out measurement in your presence and the presence of the complainant, and then dispute be sorted out. If it is not sorted out,
And before initiating any further proceeding under land grabbing, at least a notice may be issued.
pending appeal ये हो जाएगा. अभी तो measurement collector को तुम नहीं करा. वो पता रहेगा. इसी स्टेज पर. इसी स्टेज पर. In the additional affidavit filed on behalf of the petition, categorical statement has been made that the petitioner had purchased a parcel of land at measuring so and so, paragraph 2 se le lijiyega, i.e. so and so square meters of survey number so and so, village so and so. In the year 2000, wide registered sale deed dated 9/12/2019, registered with the sub-registrar so and so at serial number so and so. First off, the said land was purchased from one Vijay Bhai Kasu Bhai Gadvi for a sale consideration of rupees 199 so and so. First off, it is then contended that the petitioner is in possession of the land purchased wide sale deed, wide aforesaid sale deed, since thereafter. First off, the complainant, namely respondent number 3, however, is owner in possession of survey number
Survey number
208/2/so and so, paragraph 3 se le lijiyega. At measuring so and so, village so and so, which according to the petition is adjacent to the land purchased by the petitioner herein. First of the contention is that the dispute is, in the instant case, is largely of overlapping the area of two contiguous plots, and the claim of the complainant that the petitioner has encroached upon his land, his plot, or has acquired area more than the area covered by the sale deed executed in favor of the petitioner is incorrect. First off, it is further submitted that an application for measurement, for the spot measurement of the land in question has been filed before the DILR on
that date I need to verify. I have just now in the
DILR, which is pending consideration as on date. First off, para change. Be that as it may, for the dispute raised herein, at the stage of preliminary inquiry initiated by respondent number, initiated under the Land Grabbing Act, we do not find any good ground to keep the present writ petition pending. First off, however, the present petition is being disposed of with the observation that the petitioner herein shall move an application before the collector. Kahan ka hoga? Ahmedabad.
It's Harvard Morbi.
Collector Morbi. Collector Morbi, by writing a representation placing his claim of being in possession of the land purchased by him by registered sale deed dated 9/12/2019. First off, on the said application being filed along with the copy of this order, the collector shall issue notice to the complainant, namely respondent number 3, and constitute a revenue team of not less than 3 revenue officials to carry out the spot measurement of the site in question. First off, the report of the revenue team shall be examined by the collector on his own, and the dispute being raised by the petition and dispute between the petition and respondent number 3, namely the complainant shall be decided strictly in accordance with law. Full stop, para change kare. However, in case there is any dispute with regard to any revenue entry, comma, the revenue map or any such dispute which would require adjudication by the revenue authorities, comma, the party shall be relegated to approach the competent authority. Full stop. Full stop करेगा. The entire exercise shall be completed within a period of, the petition shall move an application within a period of 3 weeks from today, and the entire exercise shall be completed within a period of 6 weeks from the date of filing of the application. First off, for a period of 8 weeks or till the exercise is completed, comma, no coercive measure shall be taken against the petition.
Obliged. May I pay for direct service of the government?
This is direct service. You have to file application.
Please.
That is direct service. एक छह सात में भी एक wrongly notified हो गया.
They're wrongly notified.
This is wrongly notified.
Do not receive the paper.
Next thing I have to registrar listening to make check कर लीजिए हमारे यहाँ केस कितने लगे हैं. ऐसे तो काम मत कराइए, नहीं होगा तो चीफ फायदे तो काम ही नहीं करते. वही तो थोड़े इधर आ जाने चाहिए. Yes.
Supplementary board, serial number 1, Mr. K. Shah, Mr. Sushil Shukla.
Obtain the instructions from my client. He will not be pressing this relief of ultraviolet. This can damage to the sun and fingerprint. Leave it.
Yes. देखिएगा. At the outset, Mr. K. Shah, an advocate appearing for the petition, would submit that on that the petitioner has given him instructions not to press the prayer made in the writ petition seeking to challenge the voidees of Rule 153 brackets 5 of the RPF rules. What is the complete name of the rules?
RPF, Railway Protection 4 Rules of 1987.
1987. First stop. The prayer, the part of prayer A in seeking for declaration of the charge sheet being in violation of the natural justice by reading Rule 153 brackets 5 of the RPF rules, comma, being in violation of Article 14, being ambiguous and vague as also in violation of Article 14 of the Constitution of India, and the prayer likha na, haan, and being declared to be declared ultra-vires and constitutional, comma, unconstitutional, comma, is hereby dismissed as withdrawn. Full stop.
Not press may be written.
As not pressed. As not pressed. Full stop. Para change kare. For the remaining prayer made in the writ petition, challenging the orders passed by the disciplinary authority, comma, appellate and revisional authority, comma, the matter be posted before the bench dealing with the such matters, dealing with such matters as per the roster.
Great.
This issue was taken up as I was pointing out in the judgment, but it was not decided. The railway took before the apex court. I have put that as an answer.
If you want to press, we can decide. But if you don't want to press, that is your choice.
I have taken either from my client, he is not pressing.
Great.
चलिए, वो है ना ये तन्ना जी तो जल्दी जानना चाहिए।
ऑनलाइन
हम्म।
अच्छा 2 मिनट आप
Serial number 2, Mr. Bhaskar Tanna, learned senior advocate, and government leader.
Amendment 82 में it became 1 by direct and 4 by promotion.
Initially, it was ratio
Three
3
direct
was direct.
and 1 promotion.
Then
Yes.
it became 1
1:4.
Mm.
इसमें
हेलो
60 से लेके
later 1/3 हो गया तो 1/4 ही रहा।
1/4 ही रहा।
75-25 फिर शायद 1/3 हो गया।
उसके मेरी तारीख को करना बंद कर दिया है अमेंडमेंट टू द रूल जीआर में बंद कर
આપણો અવાજ સંભળાય છે કે નહીં?
Yes, just a moment. Give us a moment.
No, no. Am I visible and audible?
Yes, you are visible as well as audible.
Thank you. Please take your own time.
This rule of 1979.
Their content was that vacancies for the earlier years that is from 60 to 80. The 80 से बंद हो गया है. It was not carried forward. The direct recruitment cadre was not carried forward. So it resulted in petition to promote them, even though they were
જરા આમ લઈ લ્યો.
1:4 the ratio.
આ થોડું કટ થાય ની વગર. Yes.
If the vacancies are carried forward, then those carried forward vacancies in the next year would also be filled by direct recruitment. Carried forward vacancies. Otherwise, if we are doing these
હજી આવે છે. ખેંચાયા વગર તૂટ્યા વગર. અવાજ કેમ બંધ થઈ ગયો પરત? એ નથી ચાલતો યાર. થોડું ખત નહીં ખુદ. અને અહીંયાનું વોલ્યુમ શું છે? આનું જે વોલ્યુમ હોય પરંતુ કઈ ખોટી મહેનત કર્યા રાખે છે ભાઈ. અહીંયા પાછળ બરોબર છે.
But this issue is over after 1979, and the order to the they were commented and after 79. So they were given
Second one, the second petition was similar. There is a letter which says we want to have a. Then we want to withdraw of appeal. I want to. The second one we need to withdraw of appeal because there is no issue.
This is Mr. Tanna. Mr. Tanna, are we audible? You have.
Yes, now am I audible?
Right. So, yes, you are audible. Yes, Mr. Tanna, in the second petition,
Second petition, I'm not
pressing.
I'm not arguing because I've lost context. My lord is talking about the second matter.
So you are seeking for withdrawal of the appearance.
Yes, that's right.
So no one.
And that is 7270. बरोबर ना? I have no instructions. I have lost contact.
Of 1990. There is a note submitted by
મને આપો.
Tanna Associates, originally appearing for the petition that to withdraw appearance on the ground that the petitioner has not given information and the council has not been able to maintain contact the petition. First of all, in view of the note, in view of the said note, the appearance, in view of the said note, let a fresh notice be issued to, let a notice be issued to the petitioner intimating that the counsel previously engaged by him is not appearing in the matter and is required to engage another counsel. First of all, the notice be sent fixing date provision to RPAD. Official submit the report with regard to service of notice on the next
અવાજ
day.
કેમ લો આવે છે?
Now, for the first matter,
Yes.
2420.
I think we done.
Yes.
Mr. Tanna, you come to page 420.
430.
4220.
Okay.
Your rejoinder.
Yes, my lord. Therefore, may I read the facts first? Because if facts, yes, my lord. Page 420, paragraph
Three.
Yes, I respectfully state,
Please read this.
I respectfully state that insofar as the provisional senior list, while our grievances have been partly redressed, in my respectful submission, respondents have not applied the push-down theory in its entirety, which is envisaged in judgment of N.K. Chauhan, reiterated by the state government resolution of 4/12/86. Well, I'll pause here for a minute. Despite the judgment of Chauhan, they had not followed in 4/12/86, and there are several judgments saying that this exercise was wrong. But I read further. I respectfully submit that in this regard, while preparing the above referred seniority list, respondents have taken a cutoff date of 1/4/79. Prior to which date, respondents have not gone into issue of allocable vacancies and thereupon applying the push-down theory. To put it in other words, vacancies available prior to 1/4/79 and the push-down theory to be applied thereon has not been considered by the respondent. There is no, this is the affidavit filed by affidavit rejoined to additional affidavit on behalf of the respondents. My lords will notice is their case.
Yes.
Now what I'm going back to my
Read the first next paragraph also.
sure, my lord. With regard to aforesaid para, I further respectfully submit that pursuant to resolution of state government dated 4/12/86, various departments have revised their seniority list in accordance with the push-down theory, wherein the starting period of the seniority list is taken from 1960. I further state that the examples of same have already been provided in the petition itself, more particularly Annexure F, page 59, where final seniority list of the cadre of accounts officer, which we are not concerned with, have been prepared relying upon.
What was this push-down theory?
As they have stated in para 3, they have done it partly, and that is my grievance. And I have filed, they have filed another affidavit also on page 448.
Whether this government resolution dated 4/2/1986,
Yes,
which has been issued in view of the judgment of N.K. Chauhan,
yes.
is on record?
It is on record, but let me point out that that resolution, I'm sure my learned friend government would have done it. I'll just take it out. They are the one relying on it. But let me explain I beg your pardon?
It is at page 54.
Can you read page
that GR.
54?
Yes, my lord, I will. It is there on the, it's mine, but maybe in Gujarati.
No, it's in English.
Very good, wonderful. I'll read this, my lord. Now, I'm very happy. I may point out that this particular resolution has been discussed by division bench of this High Court several times, and based on that, they corrected later. May I read that? In civil appeal number 4, so-and-so, N.K. Chauhan versus so-and-so, briefly stated, Supreme Court of India have ruled that where recruitment... Well, can I interpret smiles from both?
No, Mr. Tanna, first you read this page 54.
Well, there was some smile, so have I committed some error?
No.
May I read further?
We were only discussing that we are free today. This is the last case.
No, sure, I'm happy, Mano. Fortunately, to be very frank, we can hear you broadly. Madam, may I read? For the proper intimation of the ruling of the Supreme Court on the advice of legal department, it has been decided that the shortfall in particular recruitment quota.
Can you read page 54?
I'm reading that, Madam.
No, it starts from in the
In the-
civil appeal
Ah,
number so and so.
I'll read it again. In the civil appeal number so and so, NK Chavan versus so and so, briefly stated, the Supreme Court of India have ruled that where recruitment to a cadre is made by promotion and direct recruitment in a prescribed ratio, the seniority of the officers in the cadre must follow the quota. For the proper implementation of this ruling of the Supreme Court, on the advice of legal department, it has been decided that the shortfall in particular recruitment quota, direct or promotion, should be carried forward in subsequent year as labeled vacancies earmarked for direct recruits or promotees, only as the case may be. The vacancies arising in the relevant subsequent year should be allocated between direct recruit and promotees in accordance with the prescribed ratio, and carried forward rule labeled vacancies of the preceding year should be added to the vacancies allocable to the direct recruitment quota or promotion quota as the case may be. On the other hand, if the appointment made in a year are in excess of number of vacancies allocable to direct / promotion quota, the direct recruitees or promotees, as the case may be, should be pushed down to the next year and adjusted against the vacancies allocable to the prospective direct or promotion quota.
So this government resolution says that
Yes.
the vacancies,
Yes,
when in a cadre, recruitment is by two sources. One is
Yes.
direct, another is promotion.
yes,
Then the seniority of the officers in the cadre shall be determined as per their quota.
carry forward, including carry forward of earlier years.
No, as per their quota. That
No,
means direct versus promoting.
Promoting. Yes,
Right. Now, for proper implementation of this preparation of seniority list, what was decided is that if a vacancy fall in a particular quota, that vacancy will be carried forward with the rider that it is labeled vacancy of that particular quota in the next recruitment year.
And
And that vacancy would be added in that quota only.
But-
Suppose it is direct
sorry.
recruitment vacancy, it would be carried forward labeling it as vacancy of direct recruitment, and it will be added in the subsequent year as the direct recruitment in the direct recruitment quota only. Then it further says that in case there is any excess appointment against the vacancies of a particular quota, so those persons who are in excess of the vacancies of that particular quota, they will be pushed down.
that's right. I have
And
no,
they will be placed in their against their vacancies only.
I
So
have no-
suppose somebody is appointed in the year 1960 or 1970 in excess of the vacancy of direct recruitment, he will
Yes.
not claim his seniority in the year of appointment. He will be pushed down and he will be placed in the seniority list wherever the direct recruitment vacancy can be placed after his appointment.
but there is no dispute.
Now, this is how this push down theory came into being, right?
That's right.
This push down theory is not applicable after the 1979, when this rule of carried forward is, this provision of carried forward is taken away with the amendment in the rules.
Manoj,
So
I'm
after 1979, whenever there is an exercise of promotion or direct recruitment, the carried forward principle was not there. Right? And carried forward principle was with respect to the direct recruitment. This
can I,
led to appointment of persons in excess of the vacancies. And that is why this carried forward principle has been taken away, because promotees were appointed in excess all the carried forward vacancies of the direct recruitees, they were filled by promotion for years together. There was
Exactly.
no direct recruitment at all.
Exactly.
So all those persons who were appointed prior to 1979, they were required to be pushed down to put up in their category of promotees only, promotion quota only. So that's in this situation, this N.K. Chauhan judgment came, and this is why this government resolution came. Now, this carried forward principle is gone after 1/4/1979. So there is no question of application of this push down theory after 1/4/1979.
Madam, can I?
And you, all the petitioners herein are promotees after 1/4/1979.
Yes, Madam, after my laws are done, can I answer that?
Yes, yes. Now please answer.
Madam, there are two aspects which we have to bear in mind. One, up to 1/4/79 or somewhere in 1979, when this resolution came, the question would be before this court from 60 to 79 or whatever period, there was a carry forward. Does it go in oblivion or not? Question number one.
That is 60 to 79, that is already done.
No, that's what.
The seniority list is prepared after pushing down
No, Madam,
those candidates.
with due respect, that is not done. I'll explain how and why. One, I'm on principles.
Then if it is not done, then you are not affected because you came, you were promoted only after 1/4/79.
No, Madam,
You are not at all affected.
No, I'm affected and
Only the direct recruits could have been affected, not you.
Madam, I'm a direct recruit in the lower quota. Therefore, I wanted my lords to read few facts.
You were junior engineer.
Madam, may I read that?
You have not been appointed by direct recruitment on the post of deputy engineer
Madam, may I therefore
or
read?
executive engineer.
Madam, there is
Your
a
case is,
Madam,
Mr.
there is
Tanna,
a-
please listen.
Sure.
Only those persons who were entitled to be appointed against direct recruitment quota could have been affected by this exercise of not conducting direct recruitment from 1960 till 79. Now, you came to be promoted
Madam, may I?
in the year 1970.
Madam, may I point out?
I was entitled for direct recruitment. So where were you?
Madam,
Mr. Tanna, is it your case that you were entitled to seek direct recruitment on the post of deputy engineer
executive
prior to
engineer.
1979?
Yes, I'll explain how and why.
So then where were you in 1979?
Madam, I'll be able to answer, but there are.
Other exams in 79, 70.
Then you are not eligible prior to 1979.
Madam, I'm assuming for a minute.
Response.
So, but can I point out few facts?
When were you appointed as junior engineer?
Madam, I'll give you my facts, but I'll give you all facts, but let me tell you something. If it is not clear, it will create confusion. Madam, the practice in Mumbai and Gujarat.
Paragraph 4, 3.
Well, I'll give all dates, but I'm saying there is one confusion which I need to clear.
Right.
Madam, if you go to my convenience note, it will clarify. There is a typical situation in Gujarat and Mumbai in particular. I don't know about other states. Now, what happens here in Gujarat is that you appear in executive engineer, deputy engineer examination together. Now read my convenience note for a few minutes. May I read that, Manoj?
Your convenience note is a list of dates.
No. Summary of facts and arguments, which is given long ago, along with the judgment of N.K. Chauhan and Badami.
We don't have it.
No, it was tendered.
That they were entitled to be
Apropos-
appointed directly, but they could have been appointed against the direct only in 1979. Prior to that, they were not qualified.
Well, that would be necessary. Well, that convenience note was given by both of us, government as well as me. And it was apropos order of Chief Justice Arvind Kumar on 22nd October 21.
We have a brief note of the case by the state authorities, but we don't have your brief note.
I can assure my lord that I've given it.
No, you must have. We are not doubting that.
And I've done it earlier than state government.
Because the state has filed it on 19/12/2022.
I have filed it earlier, my lord. So, and that note starts with judgment of Chauhan and Badami, without which and without my note, the position would not be clear. It should be either in Farad or in my lord's papers. It is necessary because my facts.
No, it is there as a separate compilation.
Very well. May I read that note? That will clarify what grievance I am making, and all questions asked by court would be adequately dealt with. Now, may I read?
Yes.
My lords, both my lords have got me.
Yes, please.
Petitioners are engineer who have passed their examination from respective colleges in 78, 79, etc. You can skip that. But they were eligible for being considered for vacancies of executive engineer and quota of direct recruit to be filled by candidates. Now, respondent number one, state government did not hold any combined competitive examination for direct recruitment to the post of Gujarat Services of Engineers Class 1 and Class 2 from 1968 to 1980. This is important. So carry forward of 12 years. This resulted in promotion of 2 to 3 deputy executive engineer who were promotees in excess of their quota prescribed by, they went more in quota of executive engineer by way of promotion, which they will have to be pushed down. Now read further. In the year 1980, they had combined competitive examination for recruitment of post of executive engineer class 1 and deputy executive engineer in July-December 1980. So I was trying to tell my lords that you appear in a combined test, and what they do thereafter is those who are in quota and higher in merit would be appointed an executive engineer, and those who are little low in merit will be appointed as deputy executive engineer, direct recruit. This is the practice followed.
Carry forward push down principle that carry forward 1920. So what he's trying to say is that 60 to 80 to carry forward vacancies, then they should be brought here to make them to keep them as having been appointed prior to 1970. How can it be done?
Now, my lord, I read further.
He says that limited number of vacancies. Petitioner 182 of this
Yes.
May I read para 1.4? The respondent assessed the vacancies for the post of executive engineer and deputy executive engineer only for the year 1980. And this is the grievance. the carry forward
Ah.
vanished from 60 to 79. They came out with a resolution and said, do away with. Now, in that cadre, undoubtedly, I could have been direct recruit executive engineer, and I am making a grievance initially for direct recruitment and not promoting. But thereafter, in promoting quota, I will be down if I am down at the first stage. Now read further. In other words, there were excess and illegal promotions. Now, whichever are promotions from 60 to 79, in 80, first fault is of the government, you don't hold it. And I'll go to N.K. Chavan and point out that this is not permissible. Despite what Supreme Court said in 77, government came out with resolution in 86, and 80 they come with in between this. Now, question is of carry forward of quota. It cannot vanish for the period 60 to 79. I hope I'm clear to my lords. Now, in other words, there were excess and illegal promotion in both the cadres in excess of their quota, and hence vacancies in both the posts were to be assessed in the light of legitimate claim of direct recruits. Now I'm putting it here that if the advertisements were more carry forward quota, I could have been direct recruit executive engineer, because there is a common examination. This is one injustice. Now read further. It is a matter of common knowledge that while the interview will be held for both the posts, namely executive engineer and deputy executive engineer, depending upon the merits, some of them lower in the list would be working for sometimes in lower cadre and then would be promoted to higher cadre. But if more vacancies were advertised, I could have been there. Now further.
See, Mr. Tanna,
Yes.
whatever you are arguing is not tenable for one reason. First reason is that paragraph 3 of your writ petition, all the petitioners have completed their BE civil examination in the year 1979, 78 and 79. So none of them were qualified to be appointed either on the post of deputy engineer or on the post of executive engineer prior to 1978 and 79. So if no competitive examination was held between 1960 to 1980, that would not hamper the prospects of appointment of any of the petitioners at all. Now, the second issue is with regard to the carry forward vacancies of direct recruitment quota, which were illegally, according to you, filled prior to the 1979 rules because from the promotees. Now, the only those persons who could have been appointed by direct recruitment prior to 1979 could have raised this issue, that too at the relevant point of time. You filed this writ petition in the year 1990 or 91, alleging a dispute with regard to seniority list of you are asking us to push down those vacancies and appoint you with against the vacancies of direct recruitment quota, which ought to have been carried forward for not making any appointment for direct recruitment quota from between 60 to 1979. That cannot be done for this reason, that the vacancies were worked out in the year 1979. There was no carry forward rules in the year 1979. That validity of the rule was not challenged at the point of time when you entered into the picture. No one has challenged it in 1979. So on the date when you were selected and appointment rule was in place, your appointment is perfectly in accordance with the rules. Now, for challenging this seniority list, you cannot challenge the validity of the rules, vires of the rules, saying that this is discriminatory so far as you are concerned, because you were not born at all You were not eligible at all. There was no question of you being considered or given appointment prior to your eligibility. So this carry forward, pushing down principle will not, some promotee who is appointed prior to the year 1979 cannot be pushed down below you, saying that you were a direct recruitee appointed prior to the appointment, appointed prior to you attaining the qualification. That would amount to you being treated as eligible prior to 1979, when you were not even BE Civil. You might be intermediate at that point of time. So we cannot do this.
Madam, may I answer? That
The
is what,
year you were appointed, the year in which you were eligible. You became eligible after 78, 79, and even otherwise, those rules were in place when you were appointed. Your appointment will abide by the rules which do not carry any carry forward principle. This 1986 government resolution or the decision of the apex court in N.K. Chauhan will not give you any benefit at all.
Madam, may I answer?
That was not with regard to you.
Madam, first blush, what is being put to me is attractive. But that exactly what happened in famous Jai Singhani case. And I'll point out that judgment. But before that, I'm making one grievance, and I would like to point out N.K. Chauhan where the situation was exactly the same. Now,
Mr. Tanna, our this view is that whatever may be the situation in N.K. Chauhan, that does not concern you at all, because you were born in the cadre only in the year 1979. That N.K. Chauhan judgment, how does it benefit you? Sure.
Madam, I'll definitely answer the question, and I have to answer two questions raised by my Lord the Chief Justice.
Government resolution is 1986 government resolution.
Yes.
N.K. Chauhan judgment is 1979.
It came in 79, probably page 44.
54 judgment is
I'll just check out.
78 year please. 86.
Yes, it is page 44, Annex B.
Came in 86. And that is why they have, the government has used this cutoff date 1/1/1979.
Now, which
1/4/1979, which is the date on which this carry forward principle had gone. New rules came into force. Whatever happened with the carry forward principle, that was prior to 1/4/1979. And you all were selected after 1/4/1979.
Madam, I'm on a different, if I may now be permitted to point out the totality, it will be clear. My Lord, if I have understood my Lords correctly, there are two questions raised. One is that I was not born in the cadre.
Yes.
And exactly the same situation arose before the Supreme Court in Jai Singhani, famous case of Jai Singhani, where the promotee was income tax officer uncle and direct recruit was nephew of that income tax officer, and argument was advanced before the Supreme Court. I'll get that judgment and answer that question, that boy was not even physically born. We are not on individuals, we are on quota. And I'll point out from famous Jai Singhani's case in few minutes that quota has to go carry forward, number one. Number two.
In your case, not only that you were not born in the cadre.
Madam, I'm saying not, nephew was.
There are two submissions, there are two issues which are to be answered at the same time. One is that you were not born in the cadre, and another is that this on the date when you were appointed, this carry forward principle was not there.
But to which
I'm answering. Not in the rules.
Madam, which I'm answering as a wall, and I'll answer it by judgments, precisely. Now, I only would request
Exam. That would have opened up for him, and then he would have become an executive engineer and he would have been there. That is what
This select list would carry forward vacancies, would not increase the vacancies against which they were appointed. So that should not be done. So the number of vacancies which were occupied, they were the vacancies which were for deputy engineer in the year 1980, it was 22 posts, 104 posts. And then in the year 1981, it was 12 and 65. Now what is
Jai Singhani no gain se. Jai Singhani, jara chawda ki se na madad karna.
Vacancies are not increased by push down principle. Push down principle is only for the seniority list, not for the. That is why he was not selected as the
executive
if these vacancies are increased, he will be by applying the principle of carry forward.
And then he will be having everything activity accordingly and he will get monetary benefit.
See, the question is that the vacancies of direct recruitment cannot be increased by applying this carry forward principle when this carry forward principle was not there in the rules under which you were appointed. So the direct recruitment post will not be increased. The push down theory is only for the purposes of preparation of seniority list, not for the purposes of making selection. So what you are trying to ask us to increase the number of vacancies in the year of selection, which is of 1980 in one case and 1982 in another case.
Yes, and why am I?
Like three petitioners, petition number 1 and 2, they were appointed in 1980. Two
Yes,
petitions.
but in interview held much early.
Rest of three petitioners, they were appointed in 1981, 1982, and probably 1983.
Yes, I'm aware.
Right.
And that's in my paragraphs 2 and 3. I'm saying altogether something different.
It also does not matter if the interview took place earlier, because in any case, this selection was made under 1979 rules,
Madam,
which
much,
did not
Madam,
have the principle of carry forward. So
Madam,
vacancies, what you are asking us to recalculate the vacancies in the year of recruitment, which is 1980 and 1981.
correct.
Right?
Right.
This is what you are asking us.
Yes. And I'm asking
That
for
we
the,
cannot do.
Madam, that if I should have a pleasure of arguing to my heart's content, because up till now, I have been hearing my lord.
See, the questions are coming up in mind, so we are throwing all the
But I'm
questions to
most welcome, my lord.
so that
And
you can argue and assist us.
Yes, I will. Now, my lord, I'm happy that these questions are raised and they are very valid questions. At the first bus, they are very.
Because till now we were trying to understand the controversy
No,
which you are trying to raise before us.
Madam,
So that is why when we are asking you question, we are trying to correct ourselves. Whether we have correctly understood what you are arguing or not. Not.
Possibly not. Now, Madam, I would request another thing, purely technically, not concerning matter.
Yes.
If you stretch your neck left side for a longer time, it is better that it comes across my lord instead of the left side of my lord's, the screen. But now I'll go on merits and answer. It should be across. Maybe there may be need of two, but otherwise everyone will see on left or right. On merits, Marar answer all questions. Marar, and I'm putting it for your kind consideration. The moment that totality is taken care of, you will have a satisfactory answer. One, by 79 rules, for convenience purpose, I'm saying 79 notification rules, whatever. If they come, do they wash off the backlog of direct recruits completely? Because it is an admitted position and NK Chauhan precisely answers that. And I'll go to those paragraphs as well as Jai Singhani vis-a-vis my having not borne on it, which is answered by judgment of Jai Singhani in 1967 by 2 SCR, and I'll get parallel in the meanwhile, page 703. But I'll get parallel from either of them. You will find parallel. India. So, I'm relying on S.J. Jai Singhani, which I'll go a little later. And there's a judgment of 5 judges bench of the Honorable Supreme Court. And that's where this issue came. For the time being, I'm not going into it. I'm pointing out that issue of
all other candidates were selected. No selection counts. Vacancies, but it says what happens. See, the law is clear that there cannot be any appointment in excess of the vacancy which are not covered.
yes. Now, in all these matters, there is a vested interest of promotees, if I may say so. Direct recruitments are not held regularly as per the rule. They don't follow it. And the worst part is after what was stated in 77, in this famous case, 67 Jai Singhani, 77 NK Chauhan, and then Badami. The Supreme Court may say anything, but state governments act in their own manner. Now, therefore, what I'm trying to argue before my Lord is that first, quota of 60 to 79, whatever the date of direct recruit, is completely ignored, and should it be carried forward or not is question number 1. Question number 2 would be then advertisement of total number of posts for direct recruitment could have been less so as to do damage to direct recruit in the competitive examination of executive engineer cum deputy executive engineer. Second question. Third question, which I have to answer. Something happened in 79, page 44. Past goes, future goes, or is this role ultra vires article 14 and 16, which came in 1979. Now, I am not only on one part, I'm on both the parts. For first, I'm on the first and then I'm on second. Fourth question raised to me, or raised before to be answered by me, is even if I was not born in the cadre, do I have a right to continue, and is it a recurring injustice if a carry forward was not done? That carry forward does not disappear, it does not say disappear. From 79 onwards, whether it can validly disappear, is a different question to which I'll go. But this would mean that 60 to 79, assuming the direct recruitment quota was 3 to 1, and you will find thereafter 4 to 1, plenty of them would disappear, and that cannot disappear as I understand the law. Have I?
Yes.
Now, have I put questions properly as I understood so that I can answer it?
Yes.
Well, we try to understand each
Yes,
other
yes.
because rota quota is a headache always, and I call it lawyer's paradise. Thank you. Fine. Uh-huh.
You are referring to which judgment?
No, that's Jaisinghani, citation AIR 1967.
Take out the book.
AIR
1967,
67.
Supreme Court
Hmm.
1427.
1427.
That's right. It's a full bench judgment delivered by Justice Ramaswamy. This will answer the question of my birth in the Kedar. In that case, there was a worse situation where the boy was not born physically. I'll answer that. That is answer. Jai Singhani's answer to my being born. N.K. Chauhan will precisely answer, carry forward, will not wear.
1427.
1427. I can give parallel citation of SCR whether there is.
No, we have that. The book is taken out. Just a moment.
Very well.
Second word. It is there.
If my lord reads for the time being, head note A.
Just a moment. Just a moment.
Sure.
We have got the book.
This is that celebrated case. Income tax people. Though I must point out that SCR head notes are much better than many. My lords have SCR or AIR?
AIR.
Very well. May I read, Manoj, or?
Yes.
Manoj, I am reading head note A. Article 309, 16 and 14, income tax officer, etc. Promotions from departmental promotees and direct recruits based on reasonable guarantee under 14. Quota rule, this is important. Quota rule of promotion laid down in letter of Government of India of 1810-51. You will find this was dispute of 1944, which was heard in onwards in 1967. It is a statutory duty rule, and duties cast on the government to determine method or methods of to be employed for the purpose of filing vacancies and number of candidates to be recruited. ભાઈને કીધું છે ને ઓનલાઈન જુએ. દેખાતો નથી.
Which paragraph of this judgment you are relying upon?
No, particularly paragraph 9 and paragraph 13
9,
and 13. But
13.
yes, but some portion will have to be read to understand the facts. But shall I start reading from
Can
9?
you read?
9. The relevant law and subject is well settled. My lord got it on page 1431.
Yes.
Under Article 16, there shall be equality of opportunity for all citizens in matters relating to employment or appointment to any office under the state or appointment to office under higher officer thereunder. Article 16 of the Constitution is only an incident of application. It gives effect to the doctrine of equality. It follows that there can be reasonable classification of employees for purpose of appointment or promotion. The concept of equality in matter of promotion can be predicated only when the promotees are drawn from the same source. If the preferential treatment of one source in relation to the other is based on differences between the said two sources, said difference have a reasonable relation to the nature of the office or offices which recruitment is made, said recruitment can legitimately be sustained on basis of valid classification. Then, citing General Manager Western Railway, it is necessary to read, quote, it would be clear that matters related to employment cannot be confined only to initial matters prior to the act of employment. The narrow construction would confine the application of Article 16 and nothing else. But that clearly is one of the matters relating to the other matters relating to employment would inevitably be provision as to the salary and periodical increments, terms, leave, etc. Then these are all matters relating to employment. They are and must be deemed to be included in expression matters relating to, and that's what I'm asking here. Don't give me salary, give me deemed promotion in my effect now because it could not be heard for whatever reasons. Now, Article 16.1. What Article 16.1 guarantees equality of opportunity to all citizens in respect of all matters relating to employment, appointment to any offices under so and so. From part of the same constitutional code of guarantee and supplement each other, if that be so, there would be no difficulty in holding that the matters relating to employment must include all matters in relation to employment, both prior and subsequent to the employment, which are incidental to the employment and form part of the terms and conditions of employment. Kindly go to next page. This court further observed that Article 16.2 prohibits discrimination.
Same year in which promotion is held. The promotion was 1950 and the expectation is actually in 1950 and the verification completes probation in 1950. Then the promotion of the senior level. Then it also there is one more clause in the school where this law is this. Notwithstanding anything containing those two clauses to income tax subsequently appointed to classroom and the result of a competitive examination. This was kind of an out of turn promotion on the basis of competitive examination. Right. There was the direct recruitment, then the one is direct recruitment.
Direct recruits of earlier exams are ranked above those subsequent.
Direct recruitment of only
One exam.
Jersey hotel. As per the rank of any government examination. Officer promoted in accordance with the recommendation of the departmental promotion committee. This was one source of promotion. Before the next meeting of the shall be similar to all direct recruits appointed on the result of examination during the calendar year in which departmental promotion committee met and the 3 previous years. Probation period. 3 previous years is really the whole result of them shall be similar to all direct recruits appointed on the result of examination during the calendar year in which the department promotion committee met 1 calendar year and the 3 previous years. में जितने होंगे उन सबको promote senior होगा. Yes. Then it says notwithstanding contained in this rule, clause 3. A class 2 income tax officer subsequently appointed to class 1 on the result of a competitive examination. It is out of turn promotion. Pass and public service
સાયલન્ટ છે ને
he pass at which by the Public Service Commission, if he has passed departmental examination, he is appointed as class 1 as a result of competitive examination, class 2. And if he has passed the departmental examination held before his appointment to class 1, be deemed to be a promotee for the purpose of seniority. So even if he is appointed as class 1 on the basis of competitive examination, if he has passed the departmental examination for held before his appointment, he will be deemed. Rule is almost this would be here the basis is that then level one is considered lower than the promotee who will go promoted to the same to the either by direct competition competitive examination or by DP. Then the challenge was Article 16 classification highway. Their challenge was the concept of equality in the matter of promotion can be predicted paragraph 9. Only when the promotions are drawn from the same source. If the preferential treatment of one source in relation to the other is based on the differences between the said two sources and the said differences have a reasonable relation to the nature of an office or offices for which the recruitment is made, the said recruitment can be sustained on the basis of violation. The first question is that we have to
હવે આ પાના એવા થઈ ગયા છે કે આમ ફેરવો ને તૂટી જાય છે
14 and 16 on unjustified promoted after they enter into classroom place to service and notice that classification between direct recruitee and promoted. Like promoted are given some of the weightage over direct recruitment and 3 previous years. It was discrimination between class 1 after the recruitment and the actual working of the room kept on pushing down the direct recruitees and postponing their chances of promotion. It was submitted to all officers, services on class and after they had once recruited, there could not be distinction between direct. In this aspect, it says that if there are 2 sources, you cannot claim discrimination. You can claim only one appointed. That is what they want to do. What they say is they are equal, then they cannot be placed in the property of the. But the order is that since the relevant rule says, it says that since there are 2 different sources of recruitment, so concept of equality in the matter of promotion can be predicted and the promotees are drawn from the same source. Since it was different, the next is to consider argument rule of promotion is discrimination. Class 1 to class 3, grade 2 to class 1. That while direct recruitment has to be put in 5 years as income tax officer,
ITO promoted.
office get with a minimum of 1 year in class 1 and other 4 years being counted in class 3 to paper submitted by the operator is direct recruitment.
Grade 2 to
Grade 2. इसमें भी होगा ये thought this 154 जो हमने आपको पढ़ के
yes.
There are only 3 respondents who have been promoted or deemed promoted. इनको deemed promoted माना गया ना, though they are otherwise they are coming to the promotion but they were in class 2 since they have cleared the departmental examination before that competitive examination. They were treated. The objection of the appellant is that while they qualified in the same competitive examination, they had become senior to him because of the operation of the artificial age, by which they are treated as deemed promoted. इसी paragraph.
हाँ इसी पैराग्राफ में वो आ गया
Otherwise, they would have remained junior to him. This is about Rule 4. ये Rule 4 जो हम पढ़ा था, this rule.
ये यहाँ पे
as per. Promotee is placed senior to a director who completes probation in the year in which promotee is selected by the, so if you are selected by the departmental promotion committee in 1950 and the direct deputy completes his probation in 1950,
after 2 years.
then promotee would be senior and direct deputy will be junior.
They say that the 2 years service will be confirmed. It is confirmed that 2 years service has to be counted from the date of his joining. Or like the date of joining. उसके बाद में 2 साल के बाद आया है. It can't be senior.
The past services is not to be counted. So past services as class 2 for them is to be counted because they are treated as
मतलब केडर में पोस्ट में बात होता है तो इक्वल होना चाहिए ना कोई डिस्टिंक्शन नहीं होना चाहिए तो इसमें जॉइन जैसे कंफर्मेशन ऑन सर्टेन डेट एंड डिस्प्ले कॉन्टेक्ट प्रोविजन then the director could have to be senior because he was born in the 2 years earlier but was on probation. So the system
finding that in this context, is that a proof of arbiter requires 5%. From the rule of law is the decision. Which is that for future years, roster system to create. If not roster, then court says that you adopt the roster system.
and it shows that the decision to be predictable and
the senior. And if it is data that the promoting officer shall not count this period of service in some system, you will have to wait till to go and waiting like directly to promote.
the post. So, Anna 15 is Anna 15 is suggested.
And we are unable to accept the argument of the appellant that there is any discrimination in working of this rule. The rule of commission is inextricably linked with the right rule of wages and seniority in grade 2. If in the rule of commission the service in grade 3 is not to be taken into account, the seniority would have to be increased automatically. Then in this regard, three respondents, grade 3 as joint class 1, grade 3 response shown as senior. The objection is that while they qualified the same, they have become junior. Otherwise, on behalf of the was argued that the instance was also. There was also the further configuration did not exist. It should also that if the service of committee is entitled more than their joint, so we are accordingly have to the abuses based on a reason. If the rule to don't uphold, we proceed to consider the next question arising in this allegation of that there were excessive recruitment of committees in violation of quota rule. इसी पर हमने guide किया है तो अपनी करते. The seniority shall be recruited in the following manner. Service shall be recruited in the form by competitive examination by promotion subject to so vacancies in service filled by way of promotion. A portion between the various communities. In this letter, the government said that they decided in consultation with the Gujarat High Court. 5 years in the first instance, percentage of vacancies will be filled by the number on the basis of any surplus vacancy which cannot be filled for want of a suitable candidate, which cannot be filled by being added to the quota of vacancies to be filled by direct recruitment. There has been no argument that this case would depart to operational vacancy. Though in the petition, the argument of the right case, there were excessive recruitments of promotees. It appears that from the approach that they were formative years of service and initial reorganization, the argument has been fine. According to the argument, there was excess more than the quota. In the judgment of the High Court, the examiner has found that excess number of promotees were 31. During the hearing, we ordered Secretary of the Finance to furnish a permanent English. It is not clear from the that the quota rule is strictly followed. So, this is community vacancy seniority worked out. We would like to suggest that for future year, the roster system should be followed. Having fixed the quota in the letter, it is now not open to the government to say that it is not that the need to follow quota for each year. It is open to it after the quota on account of the particular situation. We are of the opinion that having fixed the quota in size of power and the between the two sources, there is no discussion where to alter the quota according to the exigency of the situation. As we have already, the quota rule is linked with the seniority. And unless the quota rule is strictly observed in practice, it will be difficult to hold that the seniority is unreasonable and does not happen. We are accordingly of the opinion that communities of class 2, grade 2, the class 3, 1, grade 2, the prescribed quota for each year and onwards have been illegally promoted and appearance is entitled to wait in the nature of madness, wait in the nature of madness. To adjust the seniority of phase writing, to prepare a fresh seniority after adjusting the recruitment and on onwards. So this is about the excess vacancy. Same. But this was in a situation where excess promotion has been made.
Yes.
Mr. Tanna, how this judgment helps you, Jai Singhani? We tried.
Your mic is off.
You're not audible, Mr. Tanna.
Manoj, I was muted by the Siristedar or whosoever. So now I'm.
Okay.
Manoj, this will help me this way. And therefore I read. Sir, Well, it can be technically, I'm not saying
You
anything.
muted. He was muted from here. You can do it.
But that does not mute the inter-se dialogue between my lords. If my noise does,
Mr. Tanna, how this judgment helps you, Jai Singhani?
we'll read together few paragraphs up to 13. It answers my query completely.
Where is that? Which is that paragraph? Please read.
Madam, I'm sure my lords are not in hurry. I'll read.
We are not at all in hurry. We have 40 minutes now.
Before recess, after recess,
After recess, this bench is not available. We will complete in 40 minutes.
Madam, it cannot be,
We
but
will not adjourn the matter today.
No, Madam, I will try to complete, but
Now we will not speak. We will only listen.
I am not saying for a moment. I'm only saying time starts now. I should be given.
Your time starts now. 40
But does not. Madam, read that, Madam. My answer to the question before I read the judgment is that in this judgment, the court has recognized that promotees and direct recruits have equal rights. And you cannot do away with something like of rights of promotee abruptly, as you will find here, or direct recruit, as the case may be. Now, here if you see in Jai Singhani, and I could see my lords were reading it and discussing it.
मैंने रियलाइज किया कि पुरानी फाइलों से मुझे वहां पर भी होता था एक बार रिविजन एप्लीकेशन सुनते थे.
Yes, Miss. Please continue.
Madam, therefore, I'm trying to answer first on principle and then reading few paragraphs. One, that look at the injustice caused in facts of my case. One, from 60 to 79, you do not hold any competitive examination. And therefore, quota should have been carried forward. I don't think there can be any dispute about it. Up to a date in 79. Forget my case, I'm on carry forward of vacancies. Second, when interviews are announced, as many as carry forward of the seats of direct recruit should have been advertised, which they have not advertised. Third, one fine day, so as to continue injustice to promotees, what you do, direct recruits, what you do is just cut it on that day and say, you are not entitled to any quota, carry forward, not advertise, carry forward, vanishes. And this is what precisely, if you read two judgments together, Jaisinghani and N.K. Chauhan and Badami, it will clarify it. Now, in this light, I am trying to point out the facts here, which will clearly answer, according to me, the situation. Now, may I read only some portion of paragraph 10 on page 1432. Now, I am aware that my lords are very quick and precise, but I suggest do it with those who are 40, 30 plus practice. No, not with our younger boys and girls. They get little frightened.
You are referring to para 10 of this judgment, Jaisinghani judgment.
Yes, ma'am.
Please read.
We next proceed to the consider the arguments of appellant that rule of promotion from ITO grade 2 to grade 1, grade 2 to grade 1, class 1. Grade 1 is discriminatory in character. It was contended while a direct recruit has to put in 5 years as an income tax officer. I skip because that deals with grade 1. Now go in the middle of that. For a promotee, therefore, my lord got it? In the, after referring to various grade.
Yes, yes.
For a promotee, therefore, the minimum period of service for promotion is 4 years, etc. And the promotee is placed senior to direct recruit who completes probation in the year in which promotee is selected. The direct departmental promote, if it should be laid down, that again an issue. I'm only trying to point out that here, if you don't appoint direct recruits for 12 years, I'm not concerned with promoting, I'm concerned with direct recruit, and therefore I would like to read para 11 in that context. But bottom of that para 10 is required to be read. If I may go.
Yes, yes.
If it should be laid down that the past service of income tax officer in class 2 is not to be counted, then rule 1F3 would be nullified, because directly recruited officer prior to junior to the promotee would go to grade 1 earlier than promotee officer. Now I say, if you don't advertise, don't prepare a list, and 2 illegality makes 1 legality, namely, don't do nothing for 12 years and one day say that, again when I go to proviso, I'll point out to you that rule continues to be having quota. It just takes away carry forward rule, which is not permissible, as I'll point out reading N.K. Chauhan and reading my petition. Now straight away please go to para 12. Page 1433. Left side, we proceed to consider next question arising for consideration in this appeal. That's allegation of appellant that there was excessive recruitment of promotees in violation of the quota rule. Now, this is what is the situation here as well. Rule 3 of ITO, service recruitment, is to following, the service shall be recruited by following 2. We have the same rules. We have the same rule. promotion and so and so. Then rule 4 is subject to provisions of rule 3. Government shall determine the method or methods of to be employed, etc. and number of candidates to be recruited.
Yes, yes, please read.
मैंने सुना कुछ खत्म करने का है इसलिए पूछ रहा हूँ.
We were talking that it should be, this matter should be over today.
Unfortunately, my lords are not sitting in the afternoon, but I would not take more than a day.
Right.
Rule 5. I'm sure after reading these judgments, my lords would feel that some more hearing is necessary. Don't put cutoff further on me. Cutoff has been my bone of contention of my clients.
Finish this matter today.
You can say so, and I'll not say further, but let me, if you feel that I need to argue, extend it for half a day. Rule 5 states, vacancies in the service which are filled otherwise than promotion shall be supported, between the various communities in various, 1 minute, various, this page is also tear now. Both of the petition and judgment. Give me a second. Vacancies in the service which are filled otherwise than promotion shall be apportioned between various communities in India in accordance with so and so dated 1934, etc. Then in the letter of Government of India in 1944, read petition, it is stated the recruitment to grade 2 will be made partly by promotion and partly by direct. 80% vacancies arising grade will be filled by direct recruitment, examination, and remaining 20% vacancies will be filled by basis of promotion by selection, provided suitable number of candidates are available for promotion. Here, they were in excess or not, they continue. It was also stated in the letter. It was also stated
Yes.
in the letter that if there are any vacancies which could not be filled by promotion for want of suitable candidates, this will be added to the quota of vacancies to be filled by direct recruitment. The quota was altered by Government of India subsequently, and we find that it is 66 2/3 and 33 1/3. Now what follows is very interesting for my purpose. After 33 and 3rd, on the basis of promotion and only 1 minute.
Yes.
Promotion and any surplus vacancies which cannot be filled for want of suitable candidates will be added to the quota of vacancies filled by direct recruitment. There has been no argument in this case with regard to the operation of rule between 45 to 50, though petitions appellant had alleged that in those years there were excessive recruitments of promotees. It appears from the affidavit of respondent number 1 that there were formative years of income tax service and reorganization of department was being completed, and initial period of reorganization lasted up to 50. Argument was confined to 51 to 56. According to appellant, there was excessive recruitment of 71 promotees, more than the figures permitted by the quota rule. In the judgment under appeal, the High Court has examined the matter and found that excess number of promotees was 31. Between 51 and 54. During the hearing of appeal, we had ordered the Secretary Finance Ministry to furnish the number of vacancies which had arisen from year to year from 1945 onwards. Where my learned opponent, I don't see him here, but he should satisfy the court, same thing. During the hearing of the appeal, we had ordered, etc. And other details in his affidavit means R.C. Dutt said that he was not able to work out, in spite of his best endeavors, the number of vacancies in a particular. However, statement exhibit E furnished was furnished showing number of officers recruited by 2 methods. And then they take various categories. We can skip that page and go to the next page and paragraph 13. Now, it top of page, rest of paragraph 12. It is not clear from the affidavit of Mr. Dutt whether the quota rule was strictly followed for the years in question in the counter affidavit respond number 1 to 4. There is, however, an assertion that the quota rule has been substantially complied with. Here, it has not been admittedly complied with. Now, 13. Solicitor General, on behalf of respondents number 1, 2, and 3 submitted that the quota rule was merely an administrative direction to determine recruitment from 2 different sources in proportion stated in the rule, and the breach of that quota rule was not a justifiable issue. Solicitor General said that there was, however, substantial compliance with the quota rule. That was their argument. But in absence of figures of permanent vacancies in class 1 grade 2 for the 11 years, Solicitor General was unable to say to what extent there had been deviation from the rule. Now this is important. We are unable to accept the argument of Solicitor General that the quota rule was not legally binding on the government. I emphasize on it. And it's binding to all courts having regard to the fact that is 5 full bench judgment of the Honorable Supreme Court. It is not disputed. Rule 4 of the Income Tax Officer Service is a statutory rule, and there is a statutory duty cast on government under this rule to determine the method or means of employed for the purpose of filling.
But that benefit has been granted only in respect of those excessive promotions which were done beyond the quota.
Therefore, I am saying here, if there is no direct recruitment from 60 to 79, there should be no doubt in mind of both my lords that there would have been promotions from time to time because they needed engineers, Narmada, and many things. Now, those details are required to be shown by the government to my lords, as was done by the Supreme Court during the pendency of the matter.
That can be, that according to the Supreme Court judgment, Jaisankani judgment, that can be done only with respect to those persons who were already in service by the recruitment quota.
That will answer
it can't
here.
Be in ambiguity.
Now, with due respect, that would be further clear if you read. Mano, those in service is answered here. Kindly read with me paragraph 13, which is a longer paragraph. It answers 13, 14. And 15 will answer this when you go to the years in question. So, may I therefore read, Marol? We are unable to accept, I read. It is not disputed that rule 4 of the income tax rule is a state. Skip that. Having fixed the quota. Having fixed the quota.
Suppose there was a quota. Suppose there was an application. So prior to 19, they could not even apply. There only contention that this vacancy should be brought forward in this year to increase the number of vacancies in a particular selection.
Executive one. Because the increasing vacancies of the executive one.
लोग आ जाते competitive.
Yes.
Having fixed the quota
in the same paragraph bottom, if you are reading the AIR,
yes.
We are accordingly of the opinion.
Yes. Yes. That promote is, but before that,
yes.
This is a very important portion, I believe.
So this is with regard to the excessive promotions done beyond the quota.
Maro, I am saying there are two. Therefore, if I read this, it will be clear to my lords. My submission is that the quota rule cannot be tinkered with. 1. There was a quota of 3 direct recruit, 1 promotee, 4 direct recruit, 1 promotee in my case. So your
case is that
during the period of 1960 to 79. 60 to
What relief can?
just one, I'll complete this. So from 1960 to 79, you say that the promotion and the direct recruitment quota was violated, and therefore those vacancies for direct which were filled up by the promotees to the direct recruitment quota ought to have been considered while in the examination held in which you were selected, and those vacancies ought to have been reflected in those at the time of your selection.
I'm saying
So that you could have come into the higher rank or in the higher.
no, that is not only argument. That's not only argument. There is something more.
What is
to
your
it.
relief then?
Mano, I'll go to my relief. Can I? Mano, this is a very intricate issue. Let me explain. I'm not restricting. I'm saying first, you say this many are advertised. That's one grievance I'm not making only. I'm saying duty, as I will read this paragraph, on the government was to say this many. My jumping from deputy to executive engineer is not the issue. Issue more important is, I'm not saying that is not the issue, that is initial error. But I'm asking a question to myself, are vacancies of direct recruit which were not filled in at all should be carried forward from time to time, and 1970 rules do not do away with promotion and direct recruitment quota. It may be, if I'm wrong in challenge of virus, do away with the
Carry forward.
carry forward from 1979. What happened to seat between 60 to 79, 12 years? There were lots of promotees promoted. It is reflected in that seniority list. There is no dispute about it.
So till 78 they carried forward. 79 the new rules came, they stopped.
How can they stop of past? That's the issue. That is precisely the issue in Jai Singhani. See, and I'll point out from reading of paragraph 14 and 13 that just can. You are doing injustice despite pronouncement of five judges judgment of Jai Singhani. When I say you, I mean government. Government does injustice, and the injustice is don't fill up for 12 years. Why? Chauhan will answer it. 2, if you don't fill up, one morning you get up and say, we have not carried forward, we have not advertised. Now we will today say it will not be carried forward. Can it be retrospective? Answer has to be no. There cannot be any other answer in view of these 5 judges and Chauhan and Patwardhan. I'll point out that.
Yes, please continue.
Now, read having fixed the quota. In that paragraph 13, after it says, but the quota fixed in letter must be deemed to have been fixed by the government of India in exercise of the statutory power and the rule. Now, what follows is very, very important. Having fixed the quota in the letter under Rule 4, it is now not open to the government of India to say that it is not incumbent upon it to follow the quota for each year, and it is open to it to alter the quota on account of the particular situation. See, so and so. We are of the opinion that having fixed the quota in exercise of their power under Rule 4 between 2 sources of recruitment, there is no discretion left with the government of India to alter that quota according to exigencies of situation or to deviate from the quota in any particular year at its own will and pleasure. Now, I'm asking question again and again and again, where is that quota of direct recruit gone? Is there any answer from the government? The answer is no. And two illegality makes one legality. Namely, do away with one, don't do it, then say, now it will not apply. How does it apply? Retrospectively. Now read further. As we have already indicated, the quota rule is linked up with the seniority rule, and unless the quota rule is strictly observed,
Calculated or not. Correct. In that particular year, they were two selections. There was no challenge to the vacancy. Now, it is not known as to how many vacancies were there. This judgment, which is of 1977 judgment, again data. Even in 1987, the revenue in 1981, vacancies were calculated. And then just three professionals are responding. Nobody knows what was the nature of it, what was the calculated vacancy. And just hypothetically, we are calculated. We are asking to go into a hypothetical situation and then decide.
Yes.
now I am reading that portion. As we have already indicated, the quota rule is linked up with seniority rule, and unless the quota rule is strictly observed in practice, it will be difficult to hold that seniority rule. And unfortunately, my page is torn out. I am not able to read. And unreasonable and does not, there is something missing. Can my lord read with me, my lord? If your paper is complete, my lord, the judgment is complete.
Judgment?
In para bottom of 1434, I am reading.
Para 15.
No. 13 bottom.
13
Yes.
bottom, yes. We are accordingly of the opinion that
As we have, as we have, last bottom on 13, 1434 bottom, left. I'm saying, as we have already indicated, quota rule is linked up with the seniority rule, and unless quota rule is strictly observed in practice, it will be difficult to hold that the seniority rule, and something is missing in my AIR. If my lord has the same, hold, then 2-3 words are missing.
Acha. You are reading at which paragraph?
Paragraph 13 bottom. Last 4 lines. I'm trying to look at it.
Last 4 lines. We, however, wish to make it clear.
No, we are accordingly of the opinion. I am trying to get it from SCR. There are paragraph. There are no paragraph numbers. I am on 13 left side bottom. Para 13 page 1434 bottom.
As we have already indicated, the quota rule is linked with the seniority rule.
Yes, and unless the quota rule is strictly observed in practice, it will be difficult to hold that seniority rule, that is 1F3.
Is not unreasonable and does not offend.
And then
we are accordingly of the opinion that the promotees from class 2, grade 3 to class 1, grade 2 service.
In excess. Thank you. I'm obliged. My lord, that page was torn
in excess of the prescribed quotas for each of the years 1951 to 56 and onwards.
Yes.
Have been illegally promoted, and the appellants are entitled to a writ in the nature of mandamus, commanding respondents 1 to 3
adjust the
seniority of the appellant and other officers, but only with respect to the excess promotions done.
Excess promotion done, but if you don't advertise the post in question and do not fill in direct recruit quota from 60 to 78, can you be excused? There was a quota of 75 25, there was a quota of 3 into 1, and then there was a quota 4 into 1, 80-20. Now today, direct recruit 80 for 12 years, none, 0. So I say, why do you push down someone? You have to carry forward quota, and that is answered by N.K. Chauhan. I am not asking for their push down, but where is the quota of direct recruit, and it cannot be infringed. Therefore, my lord, and there you will go through 44, 51, all these details would be Panu Madhu. I'm talking of last paragraph, last.
Summary of the facts and all.
Yes.
Cancel.
Yes.
No, only 1 minute. I'm trying to correlate the page because my
Yes, please.
that page is torn out. Just give me a minute. Now, well, I'll read it again, a few lines so that I am in tune. We are accordingly of the opinion from where I had some difficulty, my lords. I have now better copy. The promotees from class 2, grade 3 to class 1, grade 2 services excess of prescribed quota for each year 1951 to 1956 and onwards have been illegally promoted, and appellant is entitled to read in nature of mandamus commanding respondents number 1, 2, 3 to adjust the seniority of the appellant and other officers similarly placed like him and prepare a fresh seniority list in accordance with law after adjusting the recruitment for the period 1951-56. Here, like us, there was no direct recruitment. Then, onwards in accordance with quota, we however wish to make it clear that this order will not affect class who have been appointed permanently as assistant, but this order will apply to all the other officers who have been appointed assistant commissioner pursuant to orders of the High Court. Now, I am asking in terms of relief, I have not worked on the post for no fault of mine, either grant me all benefits or alternatively I am asking in my pension, give me deemed appointment on respective days of promotion in the higher cadre and give me benefits and pension. I understand this portion. Now read further. It is in this context, it is important to emphasize that an absence of arbitrary is first essential of rule of law, etc. Rule of law, which point view means decisions should be made by application of known principle. Now, they rely on Douglas, say we can definitely skip it. We then go below. After that, we would, new paragraph, like to suggest that government for future years, now this is important, the roster system should be adopted by framing an appropriate rule of working out quota between direct recruits and promotees, and that a roster should be maintained indicating the order in which appointments are made by direct recruitment and promotion in accordance with percentages fixed under state rule for each method of recruitment. My question to my lord is that if there was either 75% or 80% quota of direct recruit, where are they carried forward? And I'm saying carry it forward. And this rule, as I'll point out from our rules at page 44, does not take away earlier rights which is created statutorily. And when I go to rules for future of, I'll point out that is quota continues. Only what is discontinued is carried forward after 79. I hope I'm clear to my lords. Now read for writ petition number 5 of 66. The question arising are similar for the reasons we hold that petition should be allowed and should be granted, commanding respondent to adjust seniority of the petitioner, other officers similarly placed like him. Now, if you go to the initial facts of the case, this petition was heard in 1967 and judgment came in 62. And if you go to the facts, it would be quite clear that factually these were people who were recruited later. Now, kindly only go back to initial paragraph of the judgment for understanding the facts of the case. May I read that? Jai Singhani. That answers the query vis-a-vis my having been born in the cadre. I kindly read that facts. Some one paragraph only, which will answer the question of my lords. Read that. In his petition under Article 226 of the Constitution,
Yes. Yes, Mr. Tanna.
in his petition under Article 226, Appellant Jai Singhani
So
challenged.
you please sum up your argument, Mr. Tanna. We have left with 5 minutes only.
I cannot sum up. I have to read two judgments. It
Two
would not be-
judgments.
it would not be fair to me and my clients. I must point out this complicated issue.
Big judgment.
Two judgments.
Which are those judgments?
I pointed out N.K. Chauhan Badami and
N.K. Chauhan and Badami.
and Patwardhan.
Right. Please read
I cannot,
paragraphs.
I cannot, I'm sorry, Madam. We all have to do justice to the case. Please don't hurry it up. Give me half a day and I'll be able to read. Otherwise,
We have given you, Mr. Tanna, we have given you 1.5 hours.
Madam, half hour would not solve the problem
1.5 hours.
today.
We are hearing this matter. for
I'm
more
sorry.
than
I'm
1.5
sorry.
hours.
With due respect, Madam, this cannot be restricted. This is a complicated matter.
This is not a complicated matter.
I'm sorry. I'm
We
sorry.
have we have asked you certain questions you have not answered.
I'm answering, but my lords are in hurry.
No, we are not in hurry.
Then give me
We are
half a day.
hearing you patiently. For about 1.5 years, we are here, hours we are hearing you.
Madam, I got lesser time, but I'm not joining an issue. I say on Monday, give me,
So please read the judgment.
how do I read in 5 minutes?
N.K. Chauhan, you can read the judgment.
Madam, first I must satisfy.
Paragraph, which is the relevant paragraph which you want to
Madam,
place
if
before us.
you are expecting me to complete today, I would not be. Let me be very fair. 1. 2, I will read N.K. Chauhan, but this
Then
is
we are
Madam,
putting this matter on the next Friday at 12:30, and we will not be permitting further time. On
Provided.
that, you have to finish
provided
at 12:30 on the next Friday.
I'm
We
notified.
will not be giving further time.
But give me an assurance that I'll get more time.
We will not be speaking.
No, I don't say that.
Finishing
No,
only.
I don't say. I only
We
say.
will not be putting any question, Mr. Tanna, on the next day.
No,
Third,
I'm not
Mr.
suggesting for a
Tanna,
minute. I'm not
learned senior
suggesting.
advocate assisted by Shri
Gentleman is sitting across Noida.
Hardeep
Mahida.
Mahida, learned advocate for the petitioners at length. Full stop. However, at considerable length, kar dijiyega. However, on the request made by the learned senior advocate, the matter is posted on next Friday's 8th at 12:30 to enable him to complete his arguments. Full stop. Yes, Mr. Tanna. You have to complete your argument on the next day.
No, I fully understand. No question about it, and I will complete in 1.5 hours.
We have given you 1.5 hours today. We will give you another 1.5 hours that day. That is 1 hour. That is more than enough.
No, that's where.
In these days, In
Well,
these days in 2023, we cannot hear matters like we were, hearing was going on in 1990.
I wish it was heard on in 1990, then it
Even
would have,
then, even then,
would have
though
been
we are not
over.
able to do this, even then we have done.
It's great. I'm very grateful. But this is not a simple issue as my lord at present feeling. I'll point.
See, no, Mr. Tanna, no counsel can say that during hearing, judge will not ask the question or
No,
bench will not say
I'm-
something.
I'm-
So if the bench is asking you certain questions, asking you to give answers, that does not mean that you have been curtailed
my lord,
or hearing has been curtailed.
I'm not
This
saying,
is a dialogue between the bench and the bar.
did I ever say, I'm saying, according to
So
me, this,
we are giving you time on the next Friday, you have to finish it off.
I assure you,
That is clear and that is loud. We are not giving you further time. That is
equally,
clear, Mr. Tanna.
equally loud is my submission that I have not said.
Whatever be your submission, you formulate them and complete them on 8th at within 1 hour.
Madam,
That more than 1 hour hearing now cannot be given.
Madam, my lords are opening at 12:30. I'll finish at 2, quarter to 2.
Yeah, quarter to 2, yeah, 1:45.
I don't need more time.
15 minutes more.
And
1 hour,
let me-
15 minutes.
And let me clarify.
That is end of the matter. You formulate your argument, whatever you want to argue, please complete it.
I will. I only want to say I never objected to dialogue between us. I only said give me some more time.
Okay.
And I understand the stress on the court
No,
in
no.
view of the backlog.
There's no stress, but we have to finish the matter.
There is a stress which
I don't take stress at all.
No, not you. The High Court as a whole is under stress, lawyers and judges both. And we have our duty to do fast. Obliged to my lords.
Yes.
Page wise mentioning daily board, serial number 1 to 8, 9 to 19.
Thank you. On the request made by land counsel for the petition that a settlement talk is going on with the High Power Committee, meeting of which is scheduled on 24th December 2000.
It was there on 24th of November.
Meeting of which, and any further meeting is held.
We are awaiting for the yes.
Meeting of which was held on 24th November 2023. And that the petitioner is waiting response of the said meeting. The matter is posted on date kar dijiye. January
12th of
first Friday kar dijiye.
5th.
Sorry, this serial number 18 I thought. 18.
1/8.
I'm very sorry, madam.
Okay.
Lordship, serial number 1717. We have Mr. Advocate Mr. Viral Pandya, Lordship. Here mediation is going on to resolve the dispute, Lordship.
There is a leave note in serial number
Please, Lordship,
17.
but we here I
Wait for your turn. Yes.
20 to 30.
26 and 27. There the mediation proceedings are going on and mediation is kept on 11th of January. May I request that the matters may be kept beyond
Mediation in the mediation center.
mediation in the mediation center, madam.
Okay.
After 11th of January, any day.
Mediation report. We'll check whether mediation report is obtained or not.
Please, I'll wait.
But
We
serial
check
number
it. If there
25.
is no mediation report, then we'll
But
pass.
serial number 25. Can I request for some accommodation? I need to file an affidavit to bring certain subsequent facts on record. But the respondent company
This
is
is 21 matter.
It is, my lord, but my lord, I need to place on record the fact that the company is in liquidation. So, my lord, the proceedings cannot proceed because of that. So, under the IBC. So, my lord,
Just give me a week's time or 2 weeks time.
As paid by learned counsel for the petitioner, the matter is posted on
15th, 1/5.
5th of January.
Very 5th, fine. Obliged. No, I am for the respondent, not your lordships have said for the petition. I am for
as paid,
respondent.
Karega, as paid on behalf of by the learned counsel for the respondent.
Obliged.
Serial number 21. Here, one of the petitioners have expired. We have to take instructions in this matter. So may I request for some accommodation?
There is a sick note.
20.
Record the sick note and fix it in.
It's matter at serial number 28 in your lordship. 28. Mullahs, I'm for the respondents, Mullahs. I've been served with an affidavit. I needed a week's accommodation, Mullahs.
Okay. After a week.
I'm
Next
obliged.
Friday.
My lords, serial number 30, my lords. I'm requesting for some time, my lords.
Serial number?
30. 30.
Okay.
My lords, I need time to file rejoinder. And for the petition.
After 2 weeks.
Obliged.
I'm for the respondent. They may serve us a copy since long the rejoinder is pending.
And so,
When have you served the counter? When have you served the counter upon the
Well, it's 3-4 months.
4 months ago?
July or August.
A week's time to file rejoinder.
Please.
Note Kalija has prayed. A week's time is granted to file rejoinder for tough date.
15. 31 to 39.
Still number 36. Consensus over the name of
36.
36.
36.
Yeah, respondent agreed to with the name. Consensus.
They are agreed. Okay, you can give the slip. I'll take up the matter.
Lordship, serial number.
Give the slip where there is a consensus for arbitration and the names as well.
Lordship, serial number 39 and 40. Requesting to file an requesting your permission to file an application for substitute service.
Application for
Substitute service.
substituted service. First, we will look whether the service is proper or not.
41 to 51.
And for the petition. We are just going to copy of the
Okay. After 2 weeks.
Serial.
Okay.
Lordship, serial number 45, I am mentioning on behalf of Mr. Karthik Pandya for respondent with consent of petitioner side requesting for shorter accommodation.
For what?
Mr. Pandya is having some difficulty today, only 1 week time.
Next week.
Please, Lordship. Obliged.
52 to 61.
Serial number 57.
Okay.
Serial number 58, my lords. Mentioning
58.
Yes, yes. Mentioning on behalf of Ms. Aishwarya Gupta, my lords, we have received instructions to appear on behalf of Ahmedabad Municipal Corporation. My lords, with consent of the other side requesting for some accommodation.
Who has received instructions?
Ms. Aishwarya Gupta.
It is pointed out that Ms. MS. Aishwarya Gupta, learned advocate, has received instructions to appear on behalf of Ahmedabad Municipal Corporation. Full stop. To enable the council to enable the learned advocate to complete her instructions, the matter is posted on date
15.
after 2 weeks.
15.
Serial number 57. On behalf of Mr. Mehta, I am requesting for some. I have received affidavit in reply yesterday evening. Therefore, I am requesting for some time.
After 2 weeks.
Please, my lordship.
Serial number 59. That is 174 of 2020. The endorsement on the board shows that the address is there by RP. But permitting to give fresh address.
First, I'll check. Let us take up the matter. The matter will be taken up and then you make your submissions.
Leadership, serial number
Keep it
55.
in the priority.
Serial number 55. I appear for the petitioner. I'm requesting for a short accommodation today. I've taken consent of my learned friend. I've just been
Insufficient address में सभी workout कर लिया करिए. Take them. 56 also.
serial number 55. I appear for the petitioner. I'm requesting for a short accommodation today. I've taken consent from my learned friend.
Okay.
Reply has just been served
After
today.
2 weeks.
Obliged.
62 to 60.
Other side is appearing in this matter.
Lordships, we need to.
Because the list shows that notice not received back. But you are appearing.
I'm filing the reply today in the.
You have not filed Wakalatnama.
Lordships, reply and Wakalatnama, I have just received it today morning.
What is your name?
Aditya Mehta.
You yourself is appearing. Mr. Aditya Mehta Leonard. This is serial number 55. Mr. Aditya Mehta Leonard, advocate, has put in appearance on behalf of the respondent. He submits that his instructions are complete and he would be filing Wakalatnama within a short while.
Today,
In a day or two.
and along with the reply also. We have
Along with the reply, full stop, as read by, on behalf of the petitioner, comma, the matter is posted on date.
15.
Any convenience, obligement.
It's 63 in your lordship's board. Manas, I've just received a reply with consent. Manas, may I pray for 2 weeks?
In this for respond number 5, notice is not received back. Okay, rule not received back.
Manas, I'll,
Okay. After
2 weeks, Manas.
2 weeks.
I'm obliged, Manas.
Any other mention?
Okay, after 2 weeks.
Yeah, Liberty Lordship. Cinema 1717.
17.
Please, Lordship. My apology, Lordship. We have Mr. Advocate
We
Viral.
will take up the matter. Once the matter is taken up, then you can make your submission. There is a leave note. 47 to 47 to 50. Have you informed the other side? Okay. Okay.
Serial number 1, Mr. Ratilal P. Sakaria, CP Chanera, Mrs. Shardul Amarchand Mangaldas and peace.
There is order of coordinating bench. Letter is for only appointment of arbitrator.
The court has come to the conclusion that there occurs a dispute. There exists a dispute and there is an arbitration clause.
My lordship, we are objecting to the dispute being referred to arbitration. If my
On
lordship
what,
can just,
that argument you have made
but my
before
lordship, we've made,
before anything,
we've taken all those.
and
protections before the
those
court bench.
objections have been dealt with.
They've not been dealt with. The learned single judge had directly referred the matter to arbitration, saying that this can be decided by the arbitrator himself.
So rightly so, after dealing with those
But my
arguments,
ladyship,
after considering your argument, the learned judge has reached at the conclusion that
not
the issues
considering only
issues
noting
which you
down
are
the-
raising can be decided by the arbitrator.
My
So
ladyship,
then
at-
this issue is settled now.
at a section 11 stage, the referral court has to decide whether the dispute is arbitrable or not, my ladyship. Here we are
Okay,
disputing
but that
whether
issue has been considered.
that
That
is
issue
not
has been
my ladyship.
considered.
My ladyship may see the judgment of the learned single
Please
judge.
read.
I'll read only the operative portion. Till my ladyship may just come to
Your submissions have been considered. Paragraph 4.5. Para 4.5 of the order. Can you read?
I'll read from para 4, my ladyship.
This was your submission.
Please, my ladyship. My submissions have been recorded.
Please read. Please read.
I'll read, my ladyship.
They were considered.
Please.
Then,
Several contentions were raised in the affidavit in reply filed on behalf of respondent insurance.
no,
company.
para 4.5 of the judgment.
It was further submitted by learned advocate for insurance company that there was no arbitrable dispute has arisen, more particularly when there was a waiver of the claimed loss on part of petitioner as reflected in the consent letter. It was submitted that issue pertains to liability and not quantum, and that respondent company has not disputed its liability. It was submitted that arbitration clause mentions about the dispute as to the quantum. My ladyship, I agree that this is my submission.
This is your submission. Now,
my
please
submission.
read it further.
I'll read further. It was submitted that parties had agreed and understood that no dispute shall be referred to the arbitration if company had disputed or not accepted liability under or in respect of a policy. Therefore, the dispute was not arbitrable, which was a quantum dispute. It was sought to be emphasized. It was also contended that the petitioner accepted the payment without any coercion. It was submitted that the surveyor was an independent body who assessed net loss and pursuant thereto an amount of rupees 92 lakhs and odd was raised by the petitioner for the first time in the arbitration notice. On the other hand, it was asserted and emphasized by the petitioner that the insurance company had not fully satisfied the claim and the total claim amount was not paid. It was submitted that the surveyor report was also not made available. It was contended that it was not correct that the amount of rupees 84 lakhs 8,947 was accepted without protest. By pressing into service the decision of Supreme Court in United India Insurance versus Antique Arts, it was submitted that power to appoint an arbitrator is a judicial power and not merely administrative function. Therefore, in absence of arbitrable dispute, the powers cannot be exercised and request for appointment of arbitrator may not be acceded to. On the basis of the said case, it was submitted on behalf of respondent that when there was a full and final settlement between the parties and that there was a voluntary acceptance without any demur or protest, which indicates that the claim was finally settled between the parties. It has to be mentioned that in communication dated 25th October 2019, addressed by the petitioner to the respondent insurance company, it was requested to the company to provide a copy of the complete survey report with all enclosures. As per the say of petitioner, it wanted to understand the calculations made by the surveyor which arrived at the said figure. It was further stated in the communication thus, should I read the highlighted portion?
Not necessary.
5.2. In the same way, in legal notice dated so-and-so, which also got issued by the petitioner, the stand of the company was disputed in para 5 of the notice. Para 6. Therefore, on one hand, the company has taken a stand that petitioner is paid the amounts due and payable under the policy and there is no need to refer the disputes to arbitration under clause 13 of the policy. On the other hand, the petitioner disputes such case on various grounds. It was stated that amount of rupees 92 lakhs is wrongfully deducted while making payment of rupees 84 lakhs 19,579 in as much as total claim lodged was rupees 1 crore 76 lakhs 19,967. Therefore, the above aspect indeed travels to the adjudicatory realm, which is the function to be discharged by the arbitrator. When the claim is disputed, it is the arbitrator who may competently decide the claim. Arbitrability of the dispute is also to be decided by the arbitrator. While exercising powers under Section 8 of the Act, such questions cannot be gone into by this court, and when there is an arbitration clause, the aspects are to be decided by the arbitrator for such purpose.
Then, this is the answer to your questions.
My ladyship, precisely my objection that at a Section 11 stage, prima facie, the court has to take a view whether the dispute
This is what you have argued.
or not, my ladyship.
This is what you have argued and dealt with. You cannot repeat the same argument again and again.
If my ladyship can only...
There was a dispute with regard to the computation and the payment made to the petitioner. The stand of the insurance company is that the petitioner had accepted payment without any protest. The petitioner, on the other hand, disputed that he has received the payment under protest, and he says that whatever is the withheld amount, it is without any reason or basis, or it is not illegal.
But this protest,
this aspect of the matter cannot be dealt with by this court at the stage of Section 11 as well.
My lord's direct judgment of the Supreme Court on completely similar facts. Not even one fact is different. Completely similar facts of the Supreme Court holding exactly the same position.
When was this claim settled, and in which year this claim was made?
I'll highlight the dates, my ladyship, in a minute. The net loss that was issued.
What was the date when you settled the claim and payment was made?
Two dates. Consent letter that was issued upon the petitioner and to which the petitioner agreed upon was 24th December 2018.
24th
December 2018. That is the consent letter, which is at page 75.
When was payment made by you?
Thereafter, my ladyship, an advance discharge voucher was signed by the petitioner accepting the amount and also
when have you made the payment? Give me that date.
January 2019.
January
2019.
And the petitioner has sent a legal notice
on 2nd March 2020.
So
it
is not
after more than a year.
Yes, in the meantime he was rushing to you. who prefers to go to the court unless and until there is any kind of compulsion.
After a year,
1 year is not such a time where you can say that the dispute has become stale
but my
or
ladyship,
the claims have become extra time barred. It is not such a claim.
only my ladyship may only indulge me for a minute and come to page 42 of
No,
the
no,
reply.
we are
Only
not.
for a minute.
I'm
my
not
ladyship.
looking into that. That issue is decided.
Where they've clearly,
The,
ladyship,
by, okay. The repeated assertion to challenge the appointment of arbitrator on the part of the respondent insurance company is that the claim
if I
of
only,
the
my
petitioner.
ladyship may only see page
Sorry,
one page of the petition.
sorry,
Only
that
one.
is already decided. The claim of the petition. क्या लिखूं? Petitioner is stale, and after the consent letter was signed by the petitioner on 24/12/2018, he could not have turned around to raise any dispute. First up, the submission is that the question as to whether the dispute is arbitrable can be decided at the stage of Section 11 of the Act, Arbitration and Conciliation Act 1996. Reliance is placed on the decisions of the apex court in so and so. Kar dijiyega. Taking note of the above submissions, suffice it to note that on the dispute on the said submissions made by the learned advocate appearing for learned counsel appearing for the respondent insurance company, detailed order, a detailed judgment and order dated 22/9/2023 has been passed by my predecessor, holding in paragraph 6.1 as under colon-dash quote kar dijiyega. First up, for the aforesaid this court does not find any reason to re-enter into the claim of the contentions of the reconsider the claim contentions of the respondent insurance company that the dispute is non-arbitrable, inasmuch as a consent letter has been signed by the petitioner on 24/12/2018 and payment had been received in January 2019 without any protest. First stop, para change kare. As the parties have not been able to reach at an agreement in the matter of appointment of arbitrator, I so and so kar dijiyega, allow the application, appoint the, are you agreeable to the name?
I have suggested.
This is your suggestion, but whether you are
names
agreeable.
are not agreeable to us. We will go by any name suggested by my ladyship.
So these three names are not.
Ahmedabad-based
Okay.
arbitration.
So the appointment of the arbitrator is except these three names.
Please, my ladyship.
Except these three names, you can take the name from me. Okay. I'll give you later.
My ladyship will
And you
be
can add this.
referring the arbitration as per High Court rules, arbitration center rules.
Ah, yes, sir. Yes, yes. That would be there.
Please. Please, my ladyship. Will it please my ladyship to record that the arbitrator may first decide the issue
Obviously,
of
it is
arbitrability
within the
dispute
realm of the
first?
arbitrator.
If my ladyship can
Arbitrator
record this
will
and
decide. That is what 6.1 says.
oblige.
And I have reiterated 6.1 for that reason only.
If the arbitrator can only decide the arbitrability issue, thereafter then.
See, under section 11, I am not supposed to issue any direction to the arbitrator.
I agree, but I just
So-
had to make a.
So that is why 6.1 is reiterated.
Please, ma'am.
So it is for the arbitrator to decide.
Oblige.
Serial number 2 and 3. Mrs. Nanavati and Nanavati, Mr. Vandan Bakshi, Mr. Rohan Lavkumar.
I prefer
Please, your leadership, I'm for the applicants in serial number 2 and 3. This is an application for extension of time for passing of an award.
Okay,
Both of us jointly consent for an extension by 6 months. The
Okay.
hearing, there was a
what was
bifurcation.
1 year is passed or more than 1 year?
Yes. Yeah, a little
1 year has passed and thereafter 6 months extension has been sought by both the parties. 20th November 2023 is the expiry of the 6 months,
20th November,
2023. In the meanwhile, the final hearing of the first stage of arbitration has already concluded and it is reserved for passing of an award.
Likhiga, on the joint request made by learned counsels for the parties, comma, considering the prayer made in the application, comma, the term of the arbitrator is extended for a further period of 6 months with effect from 2011-2023 in view of section so and so. What is the provision? Section
29A.
29A of the Act 2000, Arbitration and Conciliation Act 1996. Full stop. The application is accordingly allowed. This is civil application number 1 of 23.
miscellaneous. civil.
Miscellaneous civil application. 29 capital A.
May I also make a small request, Your Ladyship? These are matters where 15 arbitrations were referred to a sole arbitrator. In fact, a common hearing and a common award is going to be passed. Today, only 2 matters are listed. There are 13 more. They are already filed. Subject to
Can you
removal
give
of
the
office
list?
objection, I will,
Can you give the list?
I will give the list.
I'll get them on the next date and then pass.
I'm deeply obliged.
Grateful.
You can give it to the registrar listing. It all will be listed.
I'm honest.
So today only 2 are.
Today, only 2 are there out of 15.
You have filed applications in all matters?
Applications are all filed, Your Ladyship.
Okay.
I'm honest.
Serial number 4, Mr. Sahil M. Shah, Atul Sharma.
Application for fixing date of hearing of an arbitration petition.
Fix a date. Early date, so next week or
Yes, next week.
next week.
8th of
Apply.
Number 5, Mr. Kurven K. Desai, Mr. Rushabh H. Shah.
Yes, my lords, I appear for the petitioner. My lords, on the last occasion, I was called upon to file on affidavit regarding the stand taken by the respondent that they had initiated proceedings under MSME. And was there any suppression on my part? So, my lord, that is not so because they have withdrawn the MSME proceedings. So, I could not have, my lord, that was not even necessary. So, my intent was not to suppress.
They have withdrawn.
Not which.
Who says that they have?
My lord, I have put it on affidavit, my lord. My affidavit, my lord.
Which affidavit?
My lord, additional affidavit which we have
Date?
509, my lord. My lord has it.
In which paragraph you have stated that this proceedings has been withdrawn?
My lord may come to page 607.
No, your statement in the affidavit would matter. I'm
Correct.
not looking to the annexures.
Correct, correct. My lord may come to para number 6. Para 6, my lord.
You say that you have received a letter withdrawing.
From them, with that they have withdrawn it.
Where is the order?
Correct. Now, my lord, that is a interesting part. My lord, order we received just yesterday because my lord had on the last occasion directed that there seems to be some suppression. If at all, I should put it on affidavit. Rather, both the parties should put it on
Have you
affidavit.
received the order?
My lord, yesterday we received it and this is the order dated 18 November, wherein now 18-3 proceedings under MSME have begun. So, my lord, my arbitration under section 11 is much before. So, obviously, my lord, there cannot be a bar.
No, a fresh proceed. This is a fresh proceeding.
Not fresh proceeding, my lord.
Then-
Conciliation gets terminated and, my lord, reference to arbitration is made. And this, my lord, order is dated 18 November.
So then by 18 November order, there is already a conciliation termination and appointment of arbitration.
Reference made to
Initiate parties are directed to initiate proceedings under section 18(3) before the council. This is by The chairman MSME.
Correct. And my lord, the order may my lord see it is 18 November.
So
So my lord, my arbitration under section 11 is much before. So they
even
are-
then, if they are before the MSME Facilitation Council, why would this court
My
exercise
lord,
power
correct. My lord, so
under
there is-
section 11?
Correct. So my lord, there is a judgment of Calcutta High Court which might help this court, my lord. I'll just cite.
This order is by the MSME Facilitation Council only.
Yes, yes.
So then once the council has entered into a conciliation proceeding,
Correct. So my lord, may I say this, my lord?
when was this initiated?
Correct, my lord. So and this was initiated somewhere in the year which my learned friend can say it was initiated somewhere in the
2021.
My lord, may I just cite this judgment exactly on the same facts?
2021 is when.
So on the
filed
date when you have approached this court, this proceeding was pending.
Yes.
Correct, my lord. It was-
Conciliation was
pending,
see, the MSME mandates conciliation before referring the matter for arbitration.
Yes.
So once the conciliation proceeding was going on before MSME Facilitation Council,
Correct.
where was the occasion for you to file application
My
under
lord, we had
section
already
11?
refused that we are not in whatever claims they are making is false.
Whatever it may be, you will refuse here again.
No,
Your
my lord,
refusal will always be there. Denial does not make any difference.
My lord, conciliation
No,
will have
please.
to. My lord, may just consider.
Please, please give the act. and-
My lord may just see consider the judgment.
MSME.
For, yes. My lord
That
should-
it says that MSME will
Exactly, my
prevail.
lord. My lord, just
It
read out
will
the
prevail. It says that it will prevail.
My lord, exactly. May I just read out, my lord? Give me
See,
just 2
the
minutes.
judgment says that MSME Act will prevail. The proceedings before the MSME will prevail because it is a specific
It's a
legislation.
special
So
legislation.
I am also
special
saying the same thing.
Correct, my lord. Now let us read the judgment which I have cited exactly on the same facts of the case. Not a my lord, not a single word here and there. And all these points which my lord.
What has been said by the court? Can you?
I'll in the gist I'll say that the court has said that when conciliation proceedings are pending, that will not bar section 11. Only when
Okay.
conciliation proceedings end.
Now conciliation proceeding end.
And but now today, my lord, my section 11 is already there.
Maybe.
Had I filed section 11
Maybe
subsequent
as
to
on,
end of-
as, see, filing of section 11 application will not give you right for appointment of arbitrator. Only the order passed by the court will give you a right to seek the,
My lord, it is about invocation. The word used here is invocation.
please read.
Correct, my lord.
that
I'll read it.
paragraph.
My lord, para 1 onwards, because this entire from first.
No, I'm not permitting you to read the entire judgment.
No, I'll show that, my lord. The crux of the dispute in the present case is whether in the teeth of the pendency of reference under section 18 of MSME, yes, this court can pass an order under section 11 of the Arbitration Act or not. Arbitration Act 96.
See it on, come to paragraph 30.
Correct.
We don't have to read the entire judgment.
My lord, para 18 is very important.
Please read paragraph 30.
Correct. In the instant case, we are dealing with the issue whether a prior reference to MSME, which is still at the stage of conciliation and has not crossed the stage of subsection 2 at 18, debars this court from passing an order under section 11 on the basis of independent arbitration clause between the parties. My ladyship is perfectly
Please
correct.
read
Yes.
further.
The decisions cited by the petitioner are now taken up for consideration. The division bench of Madhya Pradesh High Court in so and so upheld a proposition that the stage of applicability of 96 Act, including section 9 thereof, had not been reached since the conciliation proceedings had not yet terminated. However, such proposition does not help the petitioner much simply because application under section 9 was dismissed as not maintainable, which might be construed as double-edged sword for the petitioner. My lord, may directly now come to para 37, if may I take.
Can you read it further?
Yes, yes. Now, just reading before
Can you
that-
read the next paragraph?
I'll read, madam. The question which arose for consideration in the said case was whether application under section 9 of the Act was maintainable before a reference to arbitration under section 18.3. The entire conspectus of the consideration was an arbitration under section 18.3 of the Act, and in such context, since the subsection
So
specifically
there was
provides-
issue completely different. There was an application under section 9.
No, my lord, this they are discussing about other judgment. My lord,
Can you,
my lord, I'll read further.
you can't say no every time when the court starts speaking. In this matter, there was a dispute with regard to maintainability of section 9 application or not?
No, my lord, it was
Please
section
read.
11. There was no iota of conflict in the said case, that is, they are referring to other case, wherein section 9 application was made. There is no iota of conflict in the said case between an independent reference sought under section 11 of the Act on the basis of an arbitration clause, as against the pendency of a conciliation proceeding under 2006 Act. Hence, the ratio laid down in Madhya Pradesh judgment is rather beside the point insofar as the present issue is concerned. So, this my lord case referred to the Madhya Pradesh judgment. Reading further, the division bench of Bombay High Court at Nagpur in Messrs. Steel Authority of India Supra held that there is no provision in the Act which negates or renders an arbitration agreement entered into between parties ineffective. As such, it was observed that section 24 of the Act would not have effect of negating an arbitration agreement, since section overrides only such things those are inconsistent with section 15 to 23. Now coming to 37, the same ratio is applicable in the present case. The question which has fallen for consideration before us is whether reference under arbitration sought under section 11 of the Act is at all maintainable in the teeth of pendency of conciliation proceedings. It is germane consideration as to whether there is any specific bar stipulated under 2006 Act to such reference to arbitration under section 11 of the Act. Thus, the bar contemplated under 24 of the Act clearly elaborates the overriding effect of 26 of the Act only comes into operation if and when there is anything inconsistent with section 15 to 23 contained in any other law for the time being enforced. I do not find anything inconsistent per se between section 11 of the 96 Act and reference to conciliation of the 2006 Act to attract rigor of section 24. Learned counsel for the petitioner is justified to argue that, as held in several cited judgments, the stage of arbitration under 2006 Act, that is MSME Act, only commences after failure and termination of arbitration proceedings, which remains live till the stage of section 18(2) of the Act. Hence, it cannot be said that the bar under 24 is attracted at all in the present case. There is, in the absence of such a bar, there is nothing in either of the Act to negate the provisions of section 11 of the Arbitration Act. In the present case, the existence of arbitration clause has not been.
So the proceedings were initiated and now the conciliation fails and the matter is at the stage of appointment of arbitrator. The MSME Facilitation Council has taken up the issue for appointment of arbitrator. So that MSME Facilitation Council will decide the matter.
My lord, may I just...
It is not a case where the conciliation is pending. It is a case where conciliation has failed and stage of section 18(3) has reached. Right? So section 11 and section 18(3), they are pari materia. And then section 24 gives an overriding effect to this Act of 2006. Read section 24.
Correct, my lord, I know that.
Read section 24.
Please.
It says that the provisions of section 15 to 23 shall have effect, notwithstanding any so and so. So
Correct, my lord.
overriding effect is
My lord,
given.
I understood.
So here, in that matter, the conciliation was going on and section 11 application was filed.
Yes.
The court has only said that this Calcutta High Court has said that the stage of appointment of arbitrator is not reached. That is section 18(3) stage is not reached. So there is no prohibition or there is no bar in entertaining an application under section 11. Right?
Yes.
This is what the Calcutta High Court says.
Correct.
And wherever in the present case that stage is crossed, with this, even if your application is prior in point of time, that does not matter. On the date when I am considering the application, which is today, at this stage, and in your application, you did not disclose the factum of initiation of proceeding by the respondent before MSME Facilitation Council. Even if you have refused to participate in the conciliation proceeding, there was a mandate on you to disclose the fact. So this is a clear, deliberate misrepresentation and concealment of material fact. The court may reach at one conclusion or another conclusion, that does not matter. But you could not have you could not have concealed this fact. And then in the affidavit, you say that you received a letter, they are withdrawing. There is no withdrawal. This is the same proceeding which was entered into where conciliation failed, and now there is an order of 18/11/2023. So it is a first stage concealment, and then second stage you are trying to mislead the court by saying this statement in paragraph 6 that you have received a letter and they have withdrawn. There is no withdrawal, Mr. Counsel. So in this circumstance, why would I permit you to argue the matter? First answer.
Correct. Grateful, my lords. My lord, for the first part, that is concealment on the.
No, come to the second part.
That is.
Now in the affidavit which you filed, which you say that they have withdrawn, which is incorrect.
My lord, may just come.
Which is false.
My lord, there is an.
What do you say about this?
My lord, page 607.
No, what do you say about this?
My lord, for a moment.
The proceeding was pending or not?
My lord, it was.
Why have you not disclosed?
My lord, it was not pending.
It was, conciliation was going on.
My lord, just see page.
Conciliation was going on or not? This is not a fresh proceeding.
My lord, may I just.
This is not a fresh proceeding.
My lord, may I just say this?
This is not.
I understand, my lord.
This is not a fresh proceeding, Mr. Counsel. Don't try to misguide.
I apologize. First of all, my lord, let me apologize because an impression is being made of me that, my lord, the petitioner has concealed, and that was never the intention.
No, don't say we are not. See, I'm not the question. See, I'm not at the question of intention. I'm at the question of action of the petitioner.
Correct.
Don't say that intention was not there. I'm not supposed to look to your intention. I asked you to file an affidavit to bring on record whether the proceedings is pending or not. After the court passes this order, you filed an affidavit and say that the proceedings stood withdrawn. Now you are pleading innocence by saying that this order was passed and it was served on me. I was not aware of this order.
My lord, just see when was the date of the order?
It does not matter, Mr. Counsel. This was never withdrawn. And your statement in
should I say on what document I am
your statement in this paragraph 6 is proved to be a misstatement, misguiding. And I'm taking serious view of the matter. You are called upon to furnish your explanation.
My lord, may I just, my lord, furnish my explanation on this point?
You file affidavit and furnish your explanation. You cannot get away by this.
My lord, I'll file
this attitude, and I will take serious note of this matter and impose heavy cost on this type of pleading in the court.
My lord, for a moment, my lord, just for a moment,
if you can, please don't say this. Is it the same proceeding or not? Say yes or no.
My lord, respondent writes a letter.
That letter is neither here nor there.
Writing a letter.
Notice was received by you from the MSME Council.
Please, my lord.
You appeared before MSME Council.
No, my lord.
You refused and you sent letter.
I didn't send letter, my lord.
Then when have you come to know about the matter before the MSME Council?
My lord, in 23.
When date? Don't say 23. 23 is still going on.
My lord, 14. The date, my lord, is 3rd
Don't take everything lightly.
3rd August 2023.
3rd August, how did you come to know?
My lord, from a letter which I received from MSME Facilitation Council.
Where is that letter?
My lord, at page 602. My lord, sorry, it is the first I came to know on 5th February 22. I am apologizing. 5th February 22 is the letter from MSME Council.
Where is that letter?
At page 540. My lord, page 536, sorry, 536. January 22 letter, to which I have replied on, my lord, 5th February 22.
Where is your reply?
At page, my lord, 540. The very detailed affidavit I have stated out how false the claim is. Page 599, my lord.
Why have you not disclosed these facts to the court?
My lord, like I said, my lord,
Mr. Counsel, this is very serious matter. You cannot get away by saying whatever may be the outcome, that does not matter.
and my lord may just now, since my lord is looking at the letter, my lord,
Mr. Counsel, I'm not looking to the merits of the case.
I'm not asking my lord to
So,
look at
so
the
please answer. Why have you not disclosed this?
my lord, with fullest apologies, my lord, it was, my lord,
Where is the apology?
my lord, that was,
Where is the apology?
my lord, my apology may be taken over the bar, my lord.
Where
I may allowed to,
a counsel cannot plead apology on the part of the petitioner.
my lord, the difficulties,
A
my lord,
counsel
petitioner,
cannot
my lord,
plead
the petitioner
apology.
is a private limited company.
You
They have a
cannot,
legal team.
a counsel
My lord,
cannot.
out of my lord oversight, they did not instruct
No,
the
you
advocate.
you
My lord,
don't
and
say this.
later on when this
You
point,
don't see. Don't argue like this, Mr. Counsel.
my lord, or else, my
You
lord,
are putting your client in difficulty.
my lord, I'll give a,
More and more you will argue, you will put your client in a difficulty. You are not trying to understand.
I will file an affidavit of the petitioner.
No, file an affidavit, whatever is, but I am going to impose cost on this petitioner.
My lord,
This is not done.
my lord,
See, you have to be very, very serious when you are arguing before the court.
correct.
When on the first occasion, order was passed to explain as to why you have not disclosed, you are trying to mislead the court by making a statement that you have received a letter that the respondent is withdrawing the proceeding and there is a proceeding withdrawn. There is no order. There is no decision. There is no communication to you that the proceeding stood withdrawn.
My lord, I understood what my ladyship is saying, that only on the basis of respondent's letter, I could not have considered that the proceedings are withdrawn. And it is only recently that the proceedings are withdrawn by the order dated 18 November 23.
It is not withdrawn, Mr. Counsel.
Terminated.
It is not withdrawn. You are again making a misstatement.
My lord, because
And this becomes a misstatement on the part of the counsel, which is more serious. A misstatement of the petitioner is one hand, and the counsel is making a misstatement in the court. Can you read this order? Can you say that this is withdrawal of the proceeding?
my lord, it was on because of the letter of respondent at page 607, my lord.
Dismissed with cost.
My lord, apologies.
Sorry.
My lord, may allow me to at least
I'm
file
sorry.
an additional affidavit.
I'm sorry, Mr. Counsel. We've heard you. Given you much
My lord,
opportunity.
may request to at least, my lord,
Sorry. I have given you much opportunity to argue. You are not even understanding what the court is asking you.
my lord, may just keep it on the next date. I'll
Sorry.
file a written apology of the petitioner. My lord,
Sorry.
please, my lord, it should not affect the petitioner. My lord,
Sorry.
and that was never the intention.
It will never affect you. Still that proceeding is going on. Facilitation counsel can act as an arbitrator or appoint an
My lord,
arbitrator.
requesting, my lord, may allow me to file an affidavit apologizing by the petitioner, my lord. It was never the intention to make any misstatement. in the affidavit.
Mr. Counsel,
And I understand, my
I
lord,
have heard you.
my lord, that was never the intention of the petitioner to make such a
See, the
statement.
court never, court never looks to the intention, and court cannot look to the intention. Court has to see whatever is on record.
Correct, my lord.
So I have read the record and have passed the order. That is end of the matter. Whatever I was saying was an opportunity to argue the
My
matter.
lord, my apologies, my lord.
Sorry,
My lord, kindly give me an opportunity to, my lord, put proper.
matter is over.
My lord, I apologize, my lord. Kindly give me an
Sorry.
opportunity to do so.
Sorry.
My lord, one last opportunity, my lord. My lord, I request.
Sorry, Mr.
with folded
Counsel.
hand, my lord, to do so.
Sorry.
My lord, I request because, my lord.
Sorry, Mr. Counsel. I was
My
trying to make you understand, but you are not understanding.
My,
For the last 10 minutes, I was trying to make you understand. You did not say anything about the concealment on the part of the petition.
my lord, apologies, my lord. I'll put that on affidavit, my lord.
That was an order, a specific order passed by me on the last occasion. This affidavit is an effort to misguide the court.
My lord,
And that is why I am imposing cost.
my lord, apologies.
Not because of the first act, but the second act of the petition.
My lord, I'll file an affidavit, my lord, otherwise
Sorry.
withdraw this affidavit and my lord, the petitioner
Sorry.
will seek unconditional apology.
Sorry, sir. Cost will be there and then matter can be taken care of.
My lord, may not dismiss the petition, my lord.
This has to be dismissed.
My lord, please
Not-
allow me
not-
one opportunity to, my lord, please, my lord, that was
Heard
not
you,
the
Mr.
intention, my lord.
Counsel. I am dismissing it on merits, not because of the concealment only. On both counts, that there is a concealment on the part of the petitioner and on merits also, there is a overriding effect and the proceedings are before the MSME Council, Facilitation Council. This section 11 application has to go. That's all. Next.
My lord, may
Your
just allow me
case
to
is
file
over.
an additional affidavit, my lord.
Your
I'll
case
argue
is
it on
over,
merits,
Mr.
my lord.
Counsel.
My lord, I'll bring, my lord.
Please,
My lord,
Mr.
one
Counsel,
last
don't
opportunity may be
Don't
given,
put
my
the court in an embarrassing situation. This is not your fault. The fault is of the petitioner. Next case.
Serial number
May I
6.
tender a
Mr.
judgment
Udit
that may
and
assist,
Vyas.
my lords?
Grateful.
May I tender a judgment that may assist, my lords?
This is the same proceeding which was going on.
Same proceedings. And my lords, I may read, there is it has never been withdrawn. The letter that my learned friend is referring to is a affidavit under section 76, which is mandatory, wherein we have to say that conciliation has failed and now it may further orders under 18.2 and
Obvious.
18.3 may be passed. That is that communication wherein we have said that despite efforts, conciliation has failed. That is that affidavit, my learned friend.
That affidavit is under which provision?
Is under, my lords, I may.
76.
76. 76D of the arbitration.
Arbitration Act.
Yes, my lords. Wherein we have to declare that there is termination of conciliation.
Section 7.
T6.
Yes.
76D. Termination. 76 is termination of conciliation proceedings. D by so the conciliation proceedings shall be terminated D by a written declaration of a party to the other party and the conciliator if appointed to the effect that the conciliation proceedings are terminated on the date of the declaration. So the declaration was under this provision so as to indicate that despite several efforts, since conciliation under section 18(1) could not materialize. If my lords may refer to the MSME Act for a moment. Section 18. My lords. Mary. Notwithstanding anything contained in any other law for the time being in force, any party to a dispute may, with regard to any amount due under section 17, make a reference to the Micro and Small Enterprise Facilitation Council. On receipt of a reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek the assistance of any institution or center providing alternate dispute resolution services by making a reference to such an institution or center for conducting conciliation, and the provisions of section 65 to 81 of the Arbitration and Conciliation Act 1996 shall apply to such a dispute as if the conciliation was initiated under part 3 of that act. Then subclause 3. Where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for arbitration or refer it to any institution or center providing alternate dispute resolution services for such arbitration, and the provisions of the Arbitration and Conciliation Act 1996 shall then apply to the dispute as if the arbitration was in pursuance to an arbitration agreement referred to in subsection 1 of section 7 of the Act. So it is pursuant to section 18 subclause 2 that we had filed this affidavit, indicating that despite meetings for conciliation were held, the petitioner did not remain present. That is what the order also records. Did not remain present and therefore the conciliation failed. And thereafter, order under 18.3 came to be passed.
What is this judgment say?
Well, this judgment is exactly on this point, if my lords may turn to paragraph 23 first. Let's the scheme of MSME Act
Was considered here.
was considered later on. The scheme of Arbitration Act is considered,
Right.
and relevance, my lord, is at page 28. It starts from page 25. I'm sorry, para 25.
Hmm.
It is at internal page 50.
Yes, yes.
May I read?
Hmm.
Thus, the Arbitration Act 1996 in general governs the law of arbitration and conciliation, whereas the MSMED Act 2006 governs specific nature of disputes arising between specific categories of persons to be resolved by following a specific process through a specific forum. Ergo, the MSME Act 2006 being a special law and Arbitration Act being a general law, the provisions of MSMED Act would have precedence over or prevail over the Arbitration Act 1996. In Shilpi Industries case, also this court has observed while considering the issue with regard to the maintainability and counterclaim in arbitration proceedings initiated as per sections 18 of 18.3 of the MSMED Act 2006, that the MSMED Act 2006 being a special legislation to protect MSMEs by setting out a statutory mechanism for payment of interest on delayed payments, the said act would override the provisions of the arbitration 1996, which is a general legislation. Even if the Arbitration Act 1996 is treated as a special law, then also MSMED Act having been enacted subsequently in point of time, that is in 2006, it would have an overriding effect. More particularly in view of section 24 of the MSME Act 2006, which specifically gives an effect to the provisions of section 15 to section 23 of the Act over any other law for the time being in force, which would also include arbitrations. The court also cannot lose sight of the specific non-obstant clause contained in subsection 1 of subsection 4 of section 18, which has an effect overriding any other law for the time being in force. When the MSMED Act 2006 was being enacted in 2006, the legislative was aware of the previously enacted Arbitration Act of 1996, and therefore it is presumed that the legislature has consciously made applicable the provisions of the Arbitration Act 1996 to the dispute under the MSMED Act at a stage when the conciliation process initiated under subsection 2 of section 18 of the MSMED Act 2006 fails, and when the Facilitation Council itself takes up the dispute for arbitration or refers it to any other institution or center for such arbitration. It is also significant to note that a deeming legal fiction is created in the section 18.3 by using the expression as if for the purpose of treating such arbitration as if it was in pursuance to an agreement referred to in subsection 1 of section 7 of the Arbitration Act. As held in so and so, a legal fiction presupposes the existence of the state of facts which may not exist and then works out the consequences which flow from the state of facts. Thus, considering the overall purpose, object and scheme of MSMED Act 2006 and the unambiguous expression used therein, the court has no hesitation in holding that the provisions of Chapter 5 of MSMED Act have an overriding effect in the overriding effect and the provisions of the arbitration. Let's thereafter, the issue in question is dealt with in paragraph number 28.
Yes.
There cannot be any disagreement.
Can you read paragraph 34? That is the
34?
crux.
Yes, ma'am. 34. The upshot of the above is that Chapter 5 of the MSMED Act 2006 would override the provisions of the Arbitration Act. No party to a dispute with regard to any amount due under section 17 of the MSMED Act 2006 would be precluded from making a reference to the Micro and Small Enterprise Facilitation Council, though an independent arbitration agreement exists between the parties. The Facilitation Council, which had initiated the conciliation proceedings under section 18.2 of the MSMED Act, would be entitled to act as an arbitrator despite the bar contained in section 18 of the Arbitration Act. The proceedings before the Facilitation Council Institute Center acting as an arbitrator, arbitration tribunal under section 18.3 of the MSMED Act 2006 would be governed by the Arbitration Act 1996. The Facilitation Council Institute Center acting as an arbitral tribunal by virtue of section 18.3 of the MSMED Act 2006 would be competent to rule on its own jurisdiction as also other issues in view of section 16 of the arbitration. A party who was not a supplier, that is on them. And my lords, I may just point out, thereafter in the conclusion there is Roman 3 at internal page 90, wherein the facts of the case are discussed. Roman 3, the facts are similar to the facts of the present case.
Paragraph
Roman 3, internal page. Paragraph 1 and 2, wherein the facts are. It is only a 2 paragraph. Where the Honorable Court has.
Okay.
The facts are identical.
Roman 3.
The present appeal is arising out of the judgment dated 21/8/2010, passed by the division bench of the Bombay High Court Nagpur bench. In the said case, the present appellant had supplied certain goods to the respondent.
Where are you reading? Paragraph 3.
I'm sorry. Roman 3, my lord, civil appeal number 6167 of 2013.
So paragraph 3, Roman 3 or paragraph 3?
Right.
Subpara Roman 3.
Subpara
Or paragraph 3.
One para 1 is reading of para 3.
Oh, yes.
I'm reading para 1. Should I?
Para?
Roman para 1 under Roman 3.
Of civil appeal
Okay.
6167. Of
So 6167 is Roman 3.
Roman 3.
Yes. Below that is
Yes.
para 1.
Yes.
The present appeal is arising out of
No, the appellant Messrs so and so. Roman 3 is appellant Messrs so and so.
I'm sorry, my lords.
The appellant Messrs Vidarbha Ceramics Limited, Private Limited is the para.
Internal, the pages are mentioned in the on the
No, I'm not about pages. Tell me the paragraph.
paragraph, my lords, it is Roman.
It must be subpara.
My lord, page number 19. At the top is page number 9.
Paragraphs are not given after the upshot. I read the upshot. After the upshot, these paragraphs are. After paragraph 34. my lords. It is after paragraph 34.
That is paragraph 35.
35.
So then you can mention paragraph 35.
35.
Roman is in paragraph 3 also.
No, I'm sorry. I apologize. Paragraph 35.
35. Now it is clear.
Roman 3.
Yes.
Civil appeal number 6167 of 2020.
Yes.
The present appeal is arising out of the judgment dated 21/8/2010, passed by the division bench of the Bombay High Court Nagpur bench. In the said case, the present appellant had supplied certain goods to the respondent Messrs Steel Authority of India under a contract. However, some disputes arose between the parties and therefore the appellant invoked an arbitration clause 22 contained in the agreement and proposed to appoint Justice so-and-so as the arbitrator to settle the disputes through arbitration. However, the respondent Steel Authority, invoking clause 23 of the general conditions of the contract, appointed one so-and-so as an arbitrator. The said arbitrator issued notices to the parties asking them to submit their respective claims. Messrs Vidarbha Ceramics, instead of filing a statement of claim before the arbitrator, raised objection to the arbitration by stating that the matter be either referred to Justice so-and-so or be referred to Micro and Small Enterprise.
Okay, got it. In that case, High Court has allowed Section 11 application saying
And in turn,
that in view of arbitration agreement, there was no the application or the matter before the MSME Facilitation Council was not entertainable.
Yes,
right.
Against which the Honorable Supreme Court
That
has
is
said that
that is not his argument. He only says that since the dispute has not reached at the stage of arbitration, therefore, but he cannot argue this. This is a misconceived argument.
That is all.
Dismissed with cost.
I'm immensely.
I'll decide how much cost is to be imposed.
My lord, requesting my lord's apologies and my lord.
Cost has to be there. It is not only a concealment, but an effort to misguide the court also.
Wait.
Your statement in the additional affidavit that they have withdrawn is a statement which is an effort to misguide the court. And that you cannot do.
My lord, I once again, my lord, may give an
Apology,
to file an
a
additional
counsel
affidavit, my
cannot see. Please try to understand. Don't put yourself in the shoes of the client. Never do this.
Correct, my lord.
You're an advocate. So don't put your, otherwise one day your client will say that I have never told you to tender the apology. Why have you done that? So don't do this. If there is any statement which should come from the client only,
Correct.
that should come. This is the first rule for the advocates.
Correct.
So don't put yourself in the shoes of
I'm
it.
trying to make out, think that she may file an additional affidavit to say that my lord, that was not the
That court is not permitting that. One opportunity is given, that opportunity is gone now. Next.
Number 6, Udit and Vyas.
This matter was kept for the purpose of withdrawal.
Withdrawal of?
Withdrawal of the petition. Your ladyship on the last occasion was not inclined to appoint arbitrator in.
Okay. The matter was heard.
Yes,
Then you got it adjourned to complete your instructions.
my lords.
What
My
is
lords
your-
may say that on instructions, I may be permitted to withdraw and
Okay.
it may not
At the
come in our way to initiate fresh proceedings if permissible.
fresh proceedings for
Your ladyship had last time indicated that a fresh notice under 21 may be required to be issued
Okay.
because the earlier notice does not survive.
That notice is of which date?
25th August 2021.
Okay.
The notice is at page 31.
Okay. Then the question of limitation would come in.
That my lords may say if permissible, but that liberty may be reserved.
लिखिएगा at the outset, comma, and counsel for the petition. What is your good name?
Udit Vyas.
Mr. Udit N. Vyas.
Yes.
Learned advocate appearing for the petitioner. Please for is granted. Permission to withdraw the present petition as he proposes to initiate appropriate, to take recourse to appropriate legal remedy strictly in accordance with,
Or my lords,
as is available to him.
or my lords may say fresh proceedings under the arbitration.
Appropriate legal remedy, it's covered.
My lords may
Covers
say on
it.
instructions of the client. My lords may observe it is on
Because
instruction.
she so and so at the outset you can say, upon instructions received from the petitioners would submit.
Please, ma'am. Oblige.
Ethical would submit that the petitioner has instructed him not to press the present petition in view of the above statement. The petition is dismissed as withdrawn. Post of liberty is with the petition to initiate appropriate action in accordance with law. First one, yes.
7 and 8, Mr. Double and Waki.
For the appointment of the clause, your lordship, in general clauses, your lordship will find on page 7 and actually.
Page?
Page 7 and actually. The general condition of the contract, where the my lord settlements of the disputes are under the arbitration and conciliation rules. The notice your lordship will find on page 30.
Have you undertaken this conciliation proceeding?
No, my lord, because we have given a notice, they have not, my lord, responded to the notice.
When have you sent this notice?
Lot is page 30, my lord, on 25th September.
30?
25th September 2023, Annexure D, page 30.
30. That
Is it-
Notice
Notice is
is,
served upon them, they have not responded.
see, this notice is for what purpose? For conciliation?
No, for the invocation of the, my lord,
How
arbitration.
can you invoke the arbitration clause
Because it's a
without,
small issue where, my lord, the,
without this first step? First step, come to clause 63 at page 7.
please,
Please read.
all dispute and differences of any kind whatsoever arising out of or in conciliation with the contract, whether during the process of the work or after its completion, or and whether before and after the determination of the contract, shall be referred by the contractor to chief engineer or the divisional railway manager through notice of dispute, provided that no such notice shall be served later than 30 days after the date of issue of the completion of the certificate by the engineer. chief engineer or a divisional railway manager shall within 30 days after the receipt of the contract notice of dispute notify the names of the conciliator or to the contractor.
So where is this notice of
My
dispute?
lord, my notice is, my lord, page 30, which was for the earlier, my lord, I have also approached the authorities, but they have not responded. Then after this notice,
Where is that?
lordship will find my various letters.
Where are those?
Lordship will find from the page
And in which
23
paragraph have you stated that
23 onwards.
23 onwards?
Ji.
And in which paragraph you have stated that your efforts for conciliation of the matter had turned?
But that exact wording, my lord, that conciliation would not come, my lord, but because it's a small issue with respect to the GST, which was paid by the contractor, which is required to be neutralized as even by the authority. The joint procedural order is also passed, and there is not a major issue with respect to the contracts or other.
Because this section 63 also binds you, saying that the party shall not initiate during the conciliation proceeding any arbitral or judicial proceeding in respect of the dispute. This claim you are raising since?
My lord, since my lord, page 20, since 20.
And what is the mode of service of notice which you are referring to?
By RPAD, my lord.
Where is the proof?
Page 34.
लिखेगा. Let a notice be issued to the respondent to RPAD, returnable date, steps within 1 week. List on that date. In both the matters,
Both
same?
matters, contact you. I'm obliged to. 5th of January.
Serial number 9, Mr. Munjal M. Bhatt.
Please hold. This is for appointment of arbitrator.
Hmm.
And it's the petitioner is an interior designing company. It was hired by the respondent for interior designing of an office at Ahmedabad. And an agreement was entered into between the parties, which my lords will find at page 8.
Hmm.
My lords, the arbitration clause is at page 16. Pursuant to entering into the agreement, there were some disputes which arose between the parties. According to the petitioner, the work has been completed and the site has been handed over, and some payment is outstanding. The respondent says that no, you've not completed the works properly, and therefore there is a clause under which you are supposed to make the payment to us. My lords, the arbitration clause is at page 16. Clause 14, any dispute arising between the client and interior developer shall be referred for arbitration in accordance with the provisions of the Arbitration and Conciliation Act, or as amended from time to time. My lords, I had sent a notice to them, which my lords will find at page 19, 19. After enlisting the entire claim, my lords, at page number 32, under paragraph number 14, I raised a demand of about 34 lakh rupees, and along with that, I proposed a name to be acting as the learned sole arbitrator. The notice was responded on page number 34. Relevant, if my lords may see, page number 40, 40. My lords, paragraph number 16. After giving a point-wise response to my notice, they have now raised a counterclaim, which runs from page number 40 to 42 under certain clauses of the contract. And at page 42, under paragraph number 17, they agree for arbitration, but they don't agree with the name that I have proposed. And I am not agreeable to the name that they have proposed. My lords, therefore...
They have given you an alternative name.
My lords,
They have given you
they
alternative
have given
name.
an alternate name, my lords.
Alternate name for
Please, my lords.
arbitrator.
The
So the
petitioner,
dispute is basically about the name of the arbitrator.
the name of the arbitrator.
Let a notice be issued to the respondent through RPAD, returnable date, steps within 1 week, list on date.
5th of January.
Obliged.
Number 10, Mr. Aftab Hussain Ansari.
Please, Your Lordship. The petitioners are the owner of 3 shops, Your Lordship, which was rented to the respondent, Your Lordship. There was an arbitration agreement at page number 11, clause 13, Your Lordship, that any dispute with respect to the property, page 11, Your Lordship, clause number 13. The second last clause, Your Lordship. સદર ભાડા ચિઠ્ઠીના કરાર અંગે કે તેમાં લખેલી વિગત અંગે કોઈ મતભેદ કે મનભેદ કે તકરાર ઉપસ્થિત થાય તો કોઈ પણ પક્ષકારે કોર્ટનો આશરો લેવાનો નથી અને તેનો નિકાલ લવાદી રાહે કરવાનો રહેશે. We served him the notice, Your Lordship, that they have filed a reply, Your Lordship. They denied all the allegations and therefore this
Where is the denial?
The notice, Your Lordship.
Where is the denial?
That is at page number 40 is the reply, Your Lordship. And the notice starts at page 40. And
You are the landlord. You are the landlord.
Yes, Lordship, I am the landlord. There are the 3 shops, Your Lordship. He was illegally using, the police raided the premises. They found that they are preparing the forged Aadhaar card and etc., Your Lordship. Therefore, the police sealed the premises, and from that point, which is 1.5 years, the shop is vacant, Your Lordship. There are other points also, Your Lordship, but the only dispute which they have raised is this wise, that the agreement is of year
They are
2000.
agreeable to appointment of arbitrator
Yes.
to resolve the dispute. And then paragraph, page 46.
Page 46.
This
yes.
is the reply?
Yes, Lordship. This is
Paragraph 19.
Paragraph 90. With respect to paragraph number 15 of your notice, we state and submit that all those allegations made by you in your notice are seriously disputed by my client. Hence, we are agreeable to appoint the sole arbitrator to arbitrate and resolve the dispute between your clients and our clients. Your clients can suggest any name to work as a sole arbitrator, and if his name is agreeable to our client.
Well, come here. You should have suggested the name of the arbitrator instead of coming to the court.
I'll take the instruction, Your Lordship. My Lord.
Yes.
Sometime
They
maybe-
only say that in case you are, you suggest the name. If it is not agreeable, then we will suggest.
My Lord, further page, same page, paragraph number 21 is also there, Your Lordship. Still, the right is vested in both the parties to approach the court for seeking the.
They are denying the claim.
Yes.
That everybody would deny the claim.
No, not about the denying the claim, Your Lordship.
They are not denying for arbitration reference of the matter for arbitrator. You propose that the matter be referred to the sole arbitrator.
Yes.
They agreed to it.
Yes.
Now the only question is about the name being offered by you.
Yes.
They say that you offer a name. If we are not agreeable to that, we will offer our name. We reserve our right to decide the name of the arbitrator. On this, you came to this court.
I'll take the instruction, Your Lordship. My Lord, give some a week's time, Your Lordship. I'll take the necessary instruction.
Having noted the response given by respondent to the notice sent by the petitioners herein at page 46 of the paper book, comma, when it is pointed out that the respondent is agreeable to appointment of arbitrator and the dispute only, and the question is only to the name, comma, learned counsel for the petitioner prays for his granted adjournment for the day. Prays for and adjournment, prays for adjournment to enable him to complete his instructions, comma, to make an effort to reach at a consensus at the name of the arbitrator with respondent amicably. First of all, as prayed, put up this matter, date.
Next is 2 weeks, 15. Please, Your Lordship. I'm grateful.
Serial number 11, SP Majmudar.
I appeal. So the agreement starts at page 72.
72.
I'm 71. I'm sorry.
Yes.
The date of the agreement is 8 July 2020. Between the petitioner and one Suvarna Buildcom. The petitioner is engaged in doing work of NHAI for building construction of road highways. And this was a subcontractor. The arbitration clause, your lordships, ladyships will find at page 80.
Yes.
6.8.
Right.
The governing law, just before that 6.7 also, the jurisdiction is Ahmedabad.
Right.
Even in arbitration, the seat itself in clause A is Ahmedabad.
Right.
Now, what had happened was that this agreement was, if your ladyship would kindly come to page 75, clause 3. This agreement was essentially an agreement to settle the disputes between the parties. There were certain disputes over works carried out and payments to be made. If your lordship sees, party agree that on from the date of this agreement, neither of the party would have any claim of whatsoever nature, either past or in future, against the other party. Then specifically agreed under this agreement, and each party will withdraw all claim litigations within 30 days. Party shall not file any claim, initiate any litigation of any nature after the execution of this agreement. And then your ladyship may just go back a little further at page 73 for the definition of claim.
Then where is the question of arbitration?
No, I'll tell you later.
When the dispute is settled, no claim, there is no claim against each other.
The problem is, this is how it begins. So therefore, despite this agreement,
in this agreement itself, there was a clause.
Correct.
That in case of any dispute.
Correct.
So then dispute is never
He has
settled.
filed 5 suits in Pune for execution. He has for recovery. He has also filed various arbitration against fraudulent documents. Therefore, all those, even if we accept to be true, would be superseded because there is an entire agreement clause. Therefore, we gave him a notice under section 21 that based on this settlement dispute, you can't file any claim or litigation or dispute or arbitration. And that is how this dispute arises. And therefore, the notice your ladyship will find under section 21, no reply is received by him. It's at page 109. No, I'm sorry, on 121, 125. Annexure G.
Yes.
But it is not replied.
Okay.
Respond number 1 is the main dispute. The others are my directors. I have joined them because separate suits under this disputes have been filed against them also. So they would also all be necessary parties. They are directors or joint venture holding companies of mine. And if your ladyship sees page 129, paragraph 5, the description of the parties and the short description of the disputes is also mentioned at paragraph 21.
There are disputes pending before the commercial court.
Yes, because which he could not have initiated. He initiated in 23.
That was, there are commercial suits of 21.
21, which he could not have initiated after 8/7/20.
So then go and file in
We have
those
filed our
suits.
16 and our preliminary.
See, this 8/7/2020 agreement is that the parties will have no more dispute.
Provided
they would withdraw.
Yeah, not withdraw.
They would not file any proceedings.
Claim or litigation.
So then go in the commercial suit
that we are doing.
Lay this claim
That
in
we have
view of
already
this
done.
agreement.
He has also initiated certain forged guarantees under which arbitration is invoked, where we have filed 16. But we are saying that our rights and obligations, where he was to complete works and he could not have litigated this, and the declaration that this agreement, kindly see the entire agreement clause which I have produced in this itself.
See, how can an arbitrator say that the party cannot litigate?
No, not litigate. The arbitrator.
No,
can
arbitrator can.
that this agreement supersedes the other agreements.
No, the arbitrator cannot say that parties cannot litigate.
No, I'm not saying cannot
See,
litigate.
this agreement has never been made part of any decree or any proceeding.
No, that's why the arbitration proceeding, because it's subject to arbitration. It raises a very interesting point when they will respond. The ladyship, I will be able to explain in detail, because the whole conundrum will come out as to how forged arbitration agreement contracts of guarantees were raised. Therefore, the declarations which I have sought for is 136, is 37. If your ladyship will see the reliefs.
Where is the original agreement?
The original agreement I can produce. That's not.
You have to produce that.
On that undertaking, your ladyship may issue notice. I'll produce.
No, you first produce the original agreement.
Very well. On of
This was-
8/7/20.
This was a subsequent agreement between you and the other side.
Yes.
Right? Now,
Subsequent.
what was the original agreement for?
No, the original agreement were work contracts given. There were
Various work contracts.
various work contracts. So there
Okay.
was multiple. If the whole
Right.
agreement.
Now,
I thought your
in-
ladyship were
in
talking
ref-
about this original.
No, with this reference to those work contracts,
Yes.
this was an agreement arrived, and what is this agreement say?
This agreement says that on his completion of certain works, I will make certain payments.
Right,
Now, he has not completed those works. He has not initiated arbitration under this. He has fabricated certain contracts of guarantees of the directors of the company as well as the company, and has initiated arbitrations as well as for the same reliefs. He has-
arbitration,
before a named arbitrator in the arbitration clause under the so-called purported contracts of guarantee.
so then
And
those,
that we have filed section 16. That is
Okay.
pending. For the
Okay.
same relief that he has claimed in the guarantee arbitrations before a named former district judge in Pune, and he's raised those arbitrations
see,
in Pune.
in those work contracts,
Not
they-
under the work contracts. Not, your ladyship, may I just explain? So work contracts for the timing, if your ladyship keeps it aside, because they are not relevant. Out of those work contracts, whatever claims we had against each other, that was all merged into this 8/7/20 agreement, because there were different agreements for different projects at
Right.
different times.
Right.
So this was all between two parties, the whole like balancing the accounts kind of took place. And this settlement took place. Against respond numbers 2 to 7, he, according to us, we say we deny the existence. We've raised those 16 applications before those. 7 contracts of guarantees, he said, under which there were arbitration clauses, which and the arbitrator was by name. Mr. XYZ, so and so is named as the arbitrator in Pune, where section 16 is pending. In the meanwhile, for the same reliefs and the same projects that are covered under this agreement, he also initiated commercial suits, as your ladyship have noted rightly in 21 before the Pune court, where also in one day notice was served and the next day the stage was closed and consent decree fraudulent is passed, but all those proceedings we have taken. Therefore, when all this came to light, my only remedy, because this 8/7/20, which is subsequent to those contracts of guarantees and those earlier contracts, says that this entire agreement supersedes all agreements. The law, your ladyship knows, is very clear that entire agreement clauses supersede all arrangements. The claim definition says you will not claim against guarantees or directors also. Therefore, my only remedy to have a declaration that all other agreements, if any, are superseded would be under this agreement only. And my invocation of his obligations to either pay me or complete the works or also would be available only.
where is the notice?
Yes, notice is at page 125 it begins. And the proof of service, if your ladyship would come to page 148, the tracking.
Let a notice be issued to the respondents.
Respondents.
All the respondents?
All respondents. No doubt 5 of them will be supporting me, but still a formal notice will have to go.
Okay. Respondents through RPAT, returnable date, steps within 1 week, list on the beat list.
So may I also take in addition directives?
As prayed by the counsel for the petitioner, the direct service is permitted in addition to the above.
11 proceedings are filed in Pune just to get it out of the Ahmedabad seat. That's the whole problem. Grateful to you.
Number 12, Mr. Ratilal V. Sakaria.
Higher industrial policy in the arbitration clause is on page number 28.
Page number?
28, 28. As usual, arbitration clause is in the fire policy. If any difference shall arise to the quantum to be paid under this policy, liability being otherwise admitted.
This is insurance policy.
It's an insurance policy, industrial all risk policy.
Okay. Notice.
And the one term, the surveyor assess is on page number 58. He assessed the net payable loss as rupees 3 crore 90 lakh plus amount. Against that, the insurance company has paid me on page number 71. Rupees 1 crore 5 lakh 40,569. And therefore, I issued a notice on page number 74.
70.
Invoking arbitrator. The 2-page notice. I have suggested the name of the arbitrator also.
Page
74.
74.
74.
Okay. Then.
And then reply came. It is on page number 77. The other side does not agree on invocation.
Notice कर दीजिए. Through RPAD returnable date.
Number 13, Mr. Mrugesh A. Barot, Mr. Abhishek R. Sharma.
Please. So this is for appointment one. It's page 10, clause 19 is the application. Page 10, clause 19. Any differences or dispute which may arise between.
Right. Notice. Where's the notice?
Yes, notice at page 200. It's 200.
Page
200.
21.
No, 200.
200.
Yes, annexure D call. The tracking report your lordship would find at page 209. They have not responded to these notices.
Notice returnable date. Steps.
Public.
Date you tell. All are kept on 5th January.
12. 12.
14 and 15, Mr. Pankit Pandya. Listed for order.
It is not disposed of. Title is not there. Okay, only condonation of delay has been allowed and the restoration has not been allowed. Okay. Okay. So I can pass this order today instead of making any correction. That would be better.
Lordship, I'm appearing on behalf of Pankit Ondia. We have filed.
There is you have filed an application for restoration along with an application for condonation of delay.
Yes.
Though both the applications have been allowed, but because of typographical error, order was transcribed only in delay condonation application.
Yes,
right.
Lordship.
So today I am allowing restoration application instead of making any corrections.
Please.
So restoration application is 2022 or 2023. Yes, Mr. Courtmaster. 2022 of 2023 कर दीजिएगा. This restoration is filed why? Because it was rejected on account of removal of objection.
Yes, Lordship.
Non-removal. So how
Non-removal
much time do you need?
We have removed the objection.
You have removed. In view of the statement made by land counsel for the petitioner that office objections, pursuant to which the present petition is had been dismissed. Wide order dated 13/1/2023 has already been removed. Full stop. The application for restoration is hereby allowed. The petition is restored to its original number. Yes. What is the matter? Argue? It is.
Yes, sir. Yes, ma'am. That was a delay of 132 days.
That is already allowed. Now petition is restored. You can argue the main petition. Are you ready?
Not election, my senior will argue the matter.
It is section 11. You can take the chance. At least you can take the chance.
Lordship, the respondent and petitioner are having a contract
Hmm.
in which the petitioner has given the contract of 95 lakhs and 50,000
Hmm.
to the respondent.
Hmm.
He has given the service of 60 lakh and 61,829 rupees and the service of 25 lakh 38,170 was still pending.
Hmm.
So he was asking for that service.
Hmm.
For that material, and then he said that we cannot supply that material because the rates has been increased in the market and we need extra amount for that.
So what do you want?
They have not stated the amount yet, but they are saying that you have to pay it as per the market.
So what do you want?
So we want to go for arbitration, Lordship.
So where is the clause, arbitration clause?
Lordship, page number 4 of the petition.
Hmm.
Petition. Clause 4.
Hmm.
If any dispute, controversy, or claim between the parties arises out of or in connection with this agreement, including the existence, breach, termination, validity thereof, dispute, the parties shall use all the reasonable endeavors to negotiate with a view to resolving the dispute amicably.
Hmm.
If a party gives the other party notice that a dispute has arisen, a dispute notice.
Where is the notice under section 21?
Yes, Lordship. Notice, Annexure D, 28 page. Lordship.
Page?
28.
Please see. This is a notice dated.
It is a notice dated 2109/2021.
Then after this notice, you have filed this petition.
Yes, Lordship,
On
there was the
8/3/22.
date of the notice.
Hmm?
And there was the change, there were changes in the date of the notice, and for that reason, we have filed the amendment.
Amendment. Where
Has been
is the
filed,
amendment?
Lordship. It has been filed, Lordship. CA number 1.
For amendment.
Yes, Lordship.
What do you say in the amendment?
The notice was issued again, Lordship, because of the change in the name of the arbitrator.
Change in the name of?
The arbitrator, Lordship.
You issued another notice.
Yes, Lordship.
What is the
notice
date of?
Same, just there is a change in the name of the arbitrator, Lordship.
See, what I was asking is that there is an delay on the part of the petition in approaching this court.
Yes, ma'am.
You have filed this, the notice under section 21 is of the year 2021, right?
Yes.
This notice is 21/9/21.
Yes, Lordship. And then we have reissued it on 5/4/2022 because of the changes in the name of the arbitrator.
5?
Changes in the name of the arbitrator, Lordship. Before it was Sujoy Raut, now we have given the name of the Pornishade.
You see, the notice you gave, you have suggested the name of one arbitrator.
Yes, Lordship.
Then you gave another notice suggesting the name of another arbitrator.
Yes, Lordship.
Where is the second notice?
It has been annexed as D1, Lordship, with the amendment.
I'm not getting that with the amendment.
It has been annexed with the civil application for amendment, Lordship.
ये है क्या लास्ट में देखें एक मिनट लास्ट हो गया
Civil application.
लिखिएगा the draft amendment dated 28th June 2022 is hereby allowed. Let the necessary incorporation be made. Let a notice be issued to the respondent. Main order पे लिखिएगा. Let a notice be issued to the respondent. Returnable date. Steps. Through RPAD steps.
Priority matter, serial number 17, Mr. Archit Jani has filed you note. Mr. Viral Pandya.
Please, on behalf of Mr. Viral Pandya, Lordship.
This is serial number 17.
Please.
लिखिएगा.
Mediation is going on.
In view of the office report, with regard to continuation of the mediation proceedings, the matter is posted in January, second Friday of January.
12th. HON'BLE Lordship. Thank you.
Next priority, matter 26 and 27, Mr. Ravi Karnawat and Mr. Meet S. Thakkar.
In view of the report received from the Mediation and Conciliation Center with regard to the mediation proceedings going on, the matter is posted on 12th January.
Deeply. Both the matters.
Both. Same order in both, separate orders.
And next priority, 36, Ratilal Sakaria, Mr. Vibhuti Nanavati.
I'm for the respondent, Honorable Justice case.
There is a consensus at the name of arbitrator as well.
Yes.
You are for the respondent.
Yes.
Petitioner counsel is not here. लिखिएगा. Both the parties have arrived at a consensus to refer the dispute to the arbitrator, as also at the name of the arbitrator. Full stop. I therefore allow the arbitration application and give name. Yeah.
Number 39 and 40, Mr. Hiren Vyas.
Incomplete address. Address is not provided. Have you put up notice outside? The council is not. इसमें rule actually था ना. Council is not here. Council is not here.
The endorsement is shifted elsewhere.
Call out if the council is there, I'll pass out.
Serial number 40, Mr. Hiren Vyas and Ms. Sejal Vyas.
Next time you put up notice outside that those matters where notice is unserved, they will take account.
Serial number 42. Mr. Nikund Rawal, Mr. Ramnandan Singh, Mr. S.P. Majmudar.
You are appearing for which respondent two?
Yes, I'm
Respondent number one is unserved.
Yes.
You are appearing for respondent number?
In fact, there are common partners.
He is for the petitioner.
I'm for the petitioner.
Okay.
These are two partnership firms with common partners.
Hmm.
So,
One is only the firm
yes,
and the partners two and three are represented.
my friend.
Two and three are
I'm
represented.
appearing for number two.
Okay. And what about three?
Yeah, I'm not.
Three is by Mr. Ramanandan
Yes,
Singh.
he is up here. Mr. Singh is up here. So as far as the first matter is concerned, I am not a signatory to the arbitration agreement. So that is my objection.
It's a dispute, family dispute.
No, it is a partnership dispute.
Because the firms were commenced by the husband of the applicant. In fact, I wanted to place that on record by way of affidavit today.
What?
The factum of this firm having been, both firms having been commenced by the husband of the applicant, who is now non-suited from both the firms after his death by the children and their partners without her consent. So therefore, she wants to go for arbitration to have her rights adjudicated. Because the agreement has an arbitration clause which she seeks to remove. So
Agreement is, where is the agreement? The partnership deed.
Yes.
Yes,
Partnership deed contains arbitration clause.
Yes.
And you are the
I am not a
partner.
partner. I'm not.
Who are you?
I am a third party as far as partnership is concerned. I have never participated in this partnership firm. So
You are a family member.
I'm a family member, but not a signatory to the arbitration agreement. Therefore,
No, not a signatory to the partnership firm.
Yes, and this is a dispute of partnership firm which he wants to refer.
And after death of your husband,
Yes,
whether you were inducted as a partner later,
my case is they were
you have never been inducted.
No, never been inducted.
So then why have you impleted respond number two?
That's my reply to the notice also.
Three is the partner.
That's right.
Three is the partner. Why have you impleted respond number two?
In fact, my case is that the entire action is at the behest of the respondent number two. My son.
What action?
Of non-suiting me from the firms. So
that also does not, in any case, if a family member is issuing pressure on, exerting pressure on someone else.
You can file a civil suit or what?
I don't know the point. My submission is that they are in fact, therefore this.
They have not inducted you as a partner after the death of your husband, right?
Yes, Manoj. Yes,
That the partnership deed, according to you, you had a right to be inducted as partner, being the legal heir, right? And that partnership deed contains an arbitration clause. Can you read that?
Before, Manoj, can I just make one request? Insofar as this petition is concerned, there are some documents which are necessary. Can I place it by way of?
Which petition?
Serial number 42.
Okay, you can place, that is not relevant.
Next week, I'll see to it that these documents are relevant, Manoj. Therefore, I wanted.
Maybe that documents may be, but the question is as to why this respond number two is impleted here. And why would respond number two be referred? Why would respond number two be referred to arbitration?
To demonstrate that, Manoj, I want to place these on the cost.
What is this? What are these?
It is my affidavit, Manoj.
Have you served upon him?
No, Manoj, I have just received
Without serving him, how can you file?
Requesting the refer, can we just leave next week?
Okay.
Next week.
Then next week I have filed a leave note of Friday thereafter.
Okay.
Okay.
Next to next Friday.
15th. So 42 and 43.
Yes, both are similar matter.
Okay.
Lordship, may I mention with your permission?
No, you cannot make a mention now.
Actually, Lordship, I was going to present in serial number 13 and 14, but the matter of
Serial number 30?
previous matter.
Mhm.
So I was
Yes.
on the way when the matter was
Mhm.
Lordship, in the serial number 39, as per the bailiff report,
You were required to give the correct address of the respondent.
actually, regard that, as the Lordship, the address provided
Is correct according to you.
is correct according, as per the, it
Okay.
was also given in the.
Issue notice return, notice be sent through RPAT, returnable date, steps
But,
within 1 week.
the permission,
List on the date list. Yes.
the permission, it may be the,
No alternate service. That was there, the rule was issued. Now I have issued notice through RPAD. You take steps.
Lordship, the same order can be given, page number 40.
Serial number
40. The
40.
same- It is the same issue.
Okay. Same order.
Well,
Hmm.
much.
ये आई ड्रॉप मंगा लीजिए बहुत आइस परेशान कर रही है तेरे को
Next, petition 46, Mr. Parth Patel, Mr. Vibhuti Nanavati.
Please. It's a insurance company. For an incident which occurred, he raised our claim to the insurance company of fire. That's a paltry sum was offered by the insurance company after the surveyor surveyed the premises. We sent the
Where
discharge.
is the arbitration clause?
But yes, my lords will find the arbitration clause at page 17A, the type copy.
There's a counsel appearing for the respondent insurance.
Yes, my learned
company.
friend appears.
Mr. Nanavati, okay. Yes, please. sir.
So, yes, the arbitration clause of a fire policy, if my lords.
Okay,
Yes.
now there's no deal.
Yes.
He's appearing.
Yes.
So
he's
what
appears.
is
Yes.
the issue?
So the
Do
parties.
you dispute appointment of arbitrator?
Yes, it's a covered issue, but the quantum, they offered a paltry sum. So we sent a protest under demur. We refused, we accepted under protest and demur. So we sent the discharge voucher, to which they did not transfer the amount. So we issued a notice, legal notice for the appointment of arbitrator for, the clause is not disputed. So they disputed in the reply, the quantum. Now that is to be decided by the arbitrator, my lords. That is a covered position now. Two judgments, my lords, covered the issue now. Mayavati and Duro. This is the only dispute.
Lordship, I have filed the only copy of the reply.
Reply you have not filed.
My clerk has tried to tender the reply to the office, but they did
Reply is there.
Yes,
Your reply is there.
it is fine.
So yes, what is your objection? Yes, what is your objection?
Lordship, may turn to page number.
You say that the machinery with respect to which claim was made, that was not covered under the policy because it was a subsequent purchase.
Yes.
Right?
After issuance of.
It
the-
was not automatic coverage.
automatic Inclusion in the sum insurance.
Coverage was confined to, where is the coverage? Where is this claim? The clause which you are referring to of the
Lordship is
policy.
required to go to the policy schedule. It is on page number 10. and
Page?
Page 10. Page 10, there is nature of risk description, then block description, then SMI description, wherein the last plant and machinery. But this machinery was installed subsequent to the issuance of the.
So the sum assured which is there
Yes.
with regard to plant and machinery would only cover the plant and machinery which was existing, which was already installed, which were already installed and covered under the policy.
This, yes.
Existing plant and machinery
Existing plant.
at the time of grant of the policy. There was no other claim which could have been made. There was some addition clause.
This was the clause add-on on coverage of.
Add-on clause was not signed.
It is not signed. Because Lordship have permit me to explain. They installed the machinery after the issuance of the insurance policy.
Right.
So they were required to intimate the insurance company.
Right.
That this fresh machinery has been installed.
Right.
And which could be or would be included in the sum insured.
Right.
Plant and machinery.
Right.
Then only those machinery can be insured.
Right. Now what
So,
is,
the insurance company has calculated the claim and deducted this fresh machinery.
right. So
And
whatever was not covered on the under the policy, that was excluded.
Yes.
Right.
So according to me, it is a case of.
It is not a,
rectification of
it
the
is not,
Subsequent time.
it is not a case of quantum.
Quantum.
And only in the case of quantum, the matter could have been referred to the arbitrator.
Yes. This is not the quantum dispute.
Where is the statement in this regard?
Which statement?
Non-coverage of the machinery under the policy. Yes. What do you say about this?
Yeah. My lords, ma'am, kindly have page 17I, the policy. B3 bottom minus.
Three?
17I, bottom minus 3.
Hmm.
Under any of the following circumstances, the insurance ceases to attach as regards the property affected unless the insured, before the occurrence of any loss or damage, obtains the sanction of the company signified by endorsement upon the policy by or on behalf of the company. A, if the trade or manufacture carried on be altered, comma, or if the nature of the occupation of or other circumstances affecting the building, insured or containing the insured property be changed in such a way as to increase the risk of loss or damage by insured perils.
That is irrelevant.
No, Milo,
That is irrelevant. That is a completely different clause.
no, that would cover the issue
No,
according to
it
me.
will not
That is
cover any.
completely,
No, Mr. Counsel.
because
They are
as stand-
clear, see, they are clear about the fact that whatever the insurance coverage was with regard, that included plant and machinery also.
Correct.
Right? So plant and machinery insurance can only be of a product which is already in existence. Right?
But Milos, that
So once they have covered plant and machinery, whatever plant and machinery was actually in existence, that was covered. If
No.
you have purchased certain new machinery, you ought to have informed them, included it, took insurance of that. For that purpose, you have to pay extra premium.
Milos, if my
You
lord,
cannot say that you will keep on adding machinery. You may add 1 or you may add 10 machinery. But if you add 1 or 10, that would not be the concern of the insurance company.
Milos,
But whatever is the coverage under the policy, Beyond that, you cannot have any claim.
Because for that also there is a dispute.
No,
Please see page 45, the
for
original
that,
reply.
for that,
No,
there
that
is-
original reply.
no, they have categorically stated.
No, I'm saying for the legal notice which
No,
I
no,
issued
I'm
for the claim.
looking to that legal notice, whatever reply is here.
Their reply also quantifies that
No.
amount which is less.
The,
The original
whatever,
claim was 5 crores.
see,
and all.
whatever reply is here, I will look into that.
And this
That
reply also,
legal
if I-
notice reply is neither here nor there.
very well, Manoj, even if that reply is seen.
In the affidavit in reply, they have said a categorical statement they have made.
Because that is the same reply in the legal notice. The reply
Mr.
is same.
Counsel, why would I look into the legal notice?
I'm not saying that. I'm saying it is
Please,
a
Mr.
repetition.
Counsel, show us from this reply.
Manoj,
Why are
my
you
lords have
referring to legal
page
notice?
32. Page 32.
No, reply is at page 47.
It starts from page 47. Milos, if I can take my lords to the report of the surveyor at page 32.
First come to page 47.
47, my lords are referring to page 49.
Read what has been said there
At page 48, if my lords want.
and then come to your reply.
It is submitted that the respondent insurance company has not considered the claim for damage of the wire line machinery. It is an admitted position that the SPP plant commissioned was an old plant making plastic vials, and a new vial plant machinery was installed for a glass vial. It is submitted that this machinery was purchased having invoices generated on October 21st, 21. After the inception of the policy, dated 31/3/21, it is an admitted position that the present machinery was not declared by the present petitioner under the subject policy as it was commissioned in the plant of the petitioner after the inception of the policy dated 31/3/21. It is submitted that such new machinery purchased by the petitioner after the inception of the policy would not be automatically covered. It is humbly submitted that while opting for the policy of insurance, the petitioner had not opted for add-on coverage of omission on insurance, addition, alteration and extensions. In
Now
this view of
see
the
your
matter, there
reply.
is no insurance cover available.
Now see your reply and rejoinder.
Lordships.
Paragraph
From
6.
page 52.
Paragraph 6.
Yes. With reference to what has been stated in para 3A, the deponent herein denies the contents thereof. It is denied that no insurance cover was available for the new machine, which were purchased after the policy inception date. It is further stated and submitted that the contentions raised by the respondent herein would all be matters to be decided at the stage of arbitration, and therefore the petitioner herein are not dealing with the
Then-
specifically, and the same are denied in
Then
totality.
come to paragraph 8.
With
They
reference
have
to
come
what has
out
been
with a
stated in
specific-
paragraph 3.
They have come out with a specific claim. You are giving a vague reply.
No, because this
Now
also is a
come to-
defense. He says admitted. Therefore,
Mr. They have made a categorical statement that the value of the insurance claim for the machine which was procured later has not been included. Now this is a specific statement. And then they say it is an admitted position that this machine was procured after the policy. You are not denying that fact.
no, but
Now-
that also
now-
could be a
now-
matter of
now
defense
you-
in a section 11(6) application.
Mr. Counsel, why would matter be referred to the arbitrator when it is not covered under the policy? This is the issue.
No, because the original amount also there is
No,
a deficit.
you are not saying so in the rejoinder. Please read your rejoinder.
Milos,
Without reading your rejoinder, you cannot argue this.
Milos,
That is why I am asking you to read rejoinder.
Milos, para 8 years,
Yes, read rejoinder.
with
What do you
reference
say?
to what has been stated in para 3C, the deponent herein denies the contents thereof. It is denied that the claim of the vial line machinery is not payable due to non-coverage as per the terms of the policy. It is stated and submitted that on one hand, the respondent has admitted that
Where is
amount
the
is due and
statement in
payable.
this paragraph that the dispute is with regard to original claim, which is otherwise covered under the policy? There is no such statement. Please read the paragraph.
I have stated, yes. It is stated and submitted that on one hand, the respondent has admitted that an amount is due and payable to the petitioner, while on the other hand, has taken a diametrically opposite stand by stating that there is no quantum dispute.
So then whatever you are arguing is not reflected from the record. You are arguing off the record.
Milos, if my lords have the policy, page 27, the surveyor insurance claim bill.
That survey report is not to be
No,
looked at.
I am saying for the original amount.
There is no statement in the rejoinder. See, Mr. Counsel, you are before us in petition under section 11, there is a categorical statement. There is no reply categorical. Why would I look to the survey's report? Why would I look to anything else?
Plus, I'll file a specific affidavit then because I have relied upon the.
It is your choice, but there is no affidavit here.
I'll file an affidavit. Because Lordship may have it next week. By next
But
week,
how
I'll file
could
a
you
specific.
file an affidavit? You have
Because
filed an
File
affidavit.
from the contents that the original claim.
You don't say
As
that.
it stands, I'll do that. Milord.
Come to your petition.
I'll do that, Milord,
Now
because
please
this was
read
not
your petition.
Lordships.
Where have you stated that the original claim has not been made? That claim which is not given is with regard to the coverage which you are seeking for a machine which was procured later.
No,
And
because
that
it
is-
includes that. My say that includes.
Mr. Counsel, there is a categorical statement and the details are given in the counter affidavit.
Plus, I'll try and meet with.
You
the-
are making a vague statement in the rejoinder that shows that there is an admission of that amounts to an admission on the part of the statement on the part of the insurance company that apart from this machine, no other claim was pending.
Lordship may have it next week. I'll try and I'll get those details and file an affidavit, case specific affidavit, Milord, if I can.
I'm not permitting you to file any affidavit. You can demonstrate from this only.
Very well. Lordship may have it, Milord, on the next Friday. I'll try and demonstrate.
No further
the facts.
affidavit is permitted at all.
Very well, Milord. On the facts, I'll try and get those documents.
This claim
with the
assessment
case.
details are already there in the affidavit, page 49, 48 and 49. And then the company says that protesting the claim disbursement voucher will not amount to quantum dispute. And then they are clearly saying that claim of wire line machinery is not payable due to non-coverage. That is all. To this categorical statement, there is a vague reply.
No, so I'll get that
I will not,
specific detail.
I will not be subjecting the insurance company to arbitration proceedings unnecessarily.
Milord, if my lords have paid 20, I can get that specific detail on next Friday, Milord. So otherwise, let me take proper, exact, pinpointed instructions.
Likhiga. On the categorical submission made on behalf of the Land Council appearing for the insurance company that the wire line machinery, claim for damage of which was made by the petitioner was procured after the inception of the policy, which is dated 31/3/2021. Full stop. In paragraph 3 bracket small a of the affidavit in reply filed on behalf of the generated on 21st October 2021. Full stop. It is also stated that the said machinery was not declared by the petitioner under the subject policy as could not have been declared by the petitioner under the subject policy as it was commissioned in the plant of the petitioner after inception of the policy. Full stop. The submission is that such new purchases made by the petitioner after the inception of the policy would not be automatically covered. Full stop. The further submission is that the petitioner, while opting the policy of insurance, has not opted for the inverted commas may add dash on coverage of inverted commas, omission of insure additions, comma, alteration and extensions, inverted comma close. Full stop. In view thereof, comma, no insurance cover available for the machine, new machine, There was no insurance cover available for the new machine which was purchased after the policy inception date. Full stop. It is then contended that it is then karega. In paragraph 3 brackets B of the affidavit in reply, comma, the calculation of claim amount which was paid in accordance with the terms and conditions of the subject policy for which discharge voucher was sent on 6/1/2023 is given in a table as per the claim, in a table stating the claim assessment details as per the surveyor mail dated 27/12/2022. First off, the further contention is that the discharge voucher was accepted. The contention that the discharge voucher was accepted No, you can't. The contention is that protesting the claim discharge voucher will not amount to quantum dispute in terms of clause 13 of the terms and conditions of the policy of insurance. Full stop. Against these specific contentions made in the affidavit and reply, vague assertions have been made in the affidavit and rejoinder filed on behalf of the petition, wherein only this much is submitted that the contentions raised by the petitioner, respondent herein, would be the matters to be decided at the stage of arbitration, and the claim of wireline machinery being not payable due to non-coverage as per the terms and of the policy is denied. First off, however, there is no specific reply to the categorical statement made in the affidavit filed on behalf of the respondent insurance company. First off, at this stage, comma, on the request made on behalf of the counsel for the petition, comma, the matter is posted on date kar dijiyega, to enable him to complete his instructions to make his submissions.
15? 15, please.
Which mention matters in 46, 47 to 50. Really.
47 to 50, Mr. Dheeraj M. Patel, Mr. Maulika Shah.
Let a fresh notice be. This was a notice where there is no, it is not properly served. Let us try a fresh notice through RPAD. Now you have not given the details of the respondent, how this notice would be served upon them. No, their address is not there. It is not there. Belief to kya aap karte hain? You know this very well. How belief serves the made the service. Here is no address. Even the address of the partnership firm is not there. Mr. Counsel, would you give it the details in the petition or not? Is it? Now see the petition. See the petition. It does not contain in the array of parties any detail. Are you required to give the details in the array of party or not? Why would I see page 1? Mr. Counsel? Okay. Acha, I'm sorry. Yes.
Page 2, all having address at office number 606 1
लिखिएगा लेटर fresh notice be issued through RPAD, returnable date. Notice be issued to respondents 1, 2, 3 and 4 through RPAD, returnable. Date कर दीजिए. Steps within 1 week, list down.
12. 48, there are 7 respondents. 49, there are 3.
Same issues there in all those matters. Okay. Right. Okay. Any other matter was mentioned also? One was mentioned probably for substituted service. 59.
59.
59 you made a mention.
It is not for substituted service. But 59, but that notice has returned with the endorsement left. But I will provide the fresh address on Monday itself because time is running against me under section 9.
Anybody is appearing in 56 also.
56, that is 172 of 2023.
56 में कोई appear कर रहा है.
No, 56.
56 is also same position.
I'm sorry.
There also.
Anybody is appearing in 56, you can call out if someone.
Number 56, Mr. Aditya Gupta.
No.
Mr. Santosh Goenka.
No, take 59 only.
59.
Yes, ma'am. My
Mr.
matter.
Kunjal Pandit.
But that notice by RPAD has returned with the endorsement left. But I will provide on Monday the fresh.
And counsel for the office report indicates that the notice could not be served upon the
Only one
respondent for want of correct address as prayed by land counsel for the petitioner, the matter is adjourned for the day to enable him to provide correct address of the respondent.
Kindly
To take
permit me.
fresh steps for service of notice through RPAD. Stop.
Kindly permit me additionally direct service also. May I request to keep it on 18 subject to conditions.
In case it is open for the petitioner, counsel for the petitioner to provide
Friday, next Friday.
correct address of the respondent to the office to take fresh steps for service of notice through RPAD. Full stop. On supply of the said address, notice be sent, making it returnable on dates thoda zyada time par dijiye, January 3rd week tak. In the meantime,
But only
this-
I'm sorry.
in the meantime, kar dijiye, in addition to the above, the petitioner is permitted to make a direct service.
But I would request to keep it on 8, the next Friday. Why? That under section 9, the time is running against me.
Time is running for what?
Well, the order was passed in section 9 is that either 90 days or commence.
Now you have filed a arbitration application, so the time is not running out. You have to only take steps for appointment of arbitrator.
Please, my lord.
But for any reason, if the arbitrator is not appointed, that is not your fault.
I understand.
You can always go in the court under section 9 that they are not appearing.
Please, ma'am.
They must be appearing in section 9.
They have appeared and contested, and ultimately bi-party hearing was taken place.
Then
And ultimately, I was
Next
granted
time you will
interim.
catch hold of them and get their address when the proceedings are there under section 9.
Please, ma'am. I'm ready.
So tell the court that they are avoiding the court in that way.
I can't say so, but anyway, I request on 8.
Okay.
8.
Hey guys, welcome to Scrum Master full course video by Simply Learn. In this video, we'll cover some of the most important concepts related to Scrum. We'll talk about what exactly Scrum is, the components of Scrum process, the role of a Scrum Master, the Scrum methodology, how Scrum meetings work, how Scrum and Kanban are different from one another, and finally, we'll cover some important interview questions that will help you ace your interview. Our instructors, Jeff and Chandra, will help you understand the topics with ease. Before we begin, don't forget to subscribe and click that bell icon to never miss an update from us. Now, let's jump right in.
Hi, welcome to Scrum tutorial from Simply Learn.